Good morning and welcome to you all. My name is Stefan Corvers and welcome to the Eafip Innovation Procurement Uptake webinar, Overcoming Barriers in the Legal Framework that Hamper Wider Implementation of Innovation Procurement. Before we start our webinar, just some house rules. It is possible to ask questions in the chat. If it is possible, we will answer them during the session. If not, we will collect the questions and answer them in a later document, and the document can be downloaded at a later stage. The list of participants will not be disseminated, and of course, we also record the webinar so you can look at it at a later stage at your convenience. We have never seen that, but just to be sure, in case there are technical issues or problems, we will stop for a few minutes. If the problems have not been solved, we will really actually stop and terminate the webinar, and we will record the session and make it available for download at a later stage. But for now, let's start with the agenda of today. It's going to be extremely interesting, fully packed agenda with a lot of information, and of course, we hope that's also going to be an inspiring session for all of you. We are very honored that Mr. Andras Inotai from DG RTD is going to do the introductory remarks. And once that has been done, we start with the first part, that's on the general overview, the state of play of the EU countries and the lessons learned, which are the preliminary key findings. The work methodology and the main legal barriers will be presented by Lieve Bos, and Anna Jaramillo from Corvers will dive into the remaining part of that session. We will have follow-up discussion from different countries, and for that we have dedicated some SPOCs per regions. The first SPOC, the special point of contact, is Mark Martens from Bird and Bird. He's doing the analysis for Belgium, Denmark, Finland, France, Germany, Hungary, Ireland, Italy, Poland, Spain, Sweden, and the UK. And that will be followed by David Sulovic from Cobalt, and he will do the country analysis for the Baltic countries, Latvia, Lithuania, and Estonia, and followed by Peter Katlec from Havel and Partners for Czechia and Slovakia. And the last round is for Anna Jaramillo from Corvers, who will do the country analysis for the Netherlands, Austria, Luxembourg, Greece, Malta, Bulgaria, Cyprus, Croatia, Portugal, Romania, and Slovenia. We also have the possibility to have a quick Q&A after each of the presenters, if that's needed. But anyhow, we will also have an open discussion and Q&A after the session of part one. Then we have a coffee break around 12:20 to 12:30, and then we start with the final part on a general overview on the state of play of non-EU regions, in which we dive mainly into United States and Japan, and also say a little bit about Canada and South Korea. And that's going to be presented by Asra, who is coordinating that effort. And we're going to have an open discussion Q&A, and then we come to the final part on the actual conclusions and recommendations for the Innovation Act and for the revision of the procurement directives. And we close with the Q&A, and we close the webinar around 1:30. So that's the agenda for today. I really hope that you're going to enjoy today's session. And I would like to give the floor to Mr. Andras Inotai. And perhaps, yes, I think that you're already there.
I'm here, Stefan. Good morning.
Excellent. The floor is yours.
Thank you. Thank you very much, Stefan. A very good morning to all of you. It's a real pleasure to be here. It's a terribly exciting time, very timely, our discussion and your webinar today. So let me just give you a brief intro to the whole purpose of the webinar and why the topics discussed today are now very high on the political agenda also of the EU. So it is probably no surprising information to you that the importance of the purchasing power of public sector is now on the agenda of the decision makers. We here have nearly 3 trillion euros worth of potential funding, and all this can have a huge impact on our economy, especially if a substantive part of this is channeled towards innovation. Innovation, which continues to be the key factor for addressing many of the solutions, many of the challenges that the EU is facing, whether it is climate change, whether it is traffic jams, whether it is the health or the social care systems. Much of the development, both in terms of productivity, but also in terms of offering new solutions, will have to come from innovation. Existing solutions will not be sufficient to solve these. Very interesting if you take a quick look at the chart on the upper right hand corner. There were a number of questions in the past. Is there a strong link between innovation procurement and the growth of GDP per capita? I think there's a very clear illustration that you see here that link exists. This is a very convincing chart for decision makers to step up the support for innovation procurement. We also know how innovation procurement can speed up a bit the innovation timeline. We know the role of early take-up of innovative solutions, and that's why some parts of the world have actually started investing nearly 20% of their public procurement budget on innovation procurement. Unfortunately, and maybe this is our striking starting point for the discussions today, this figure is rather close to 10% in the EU. So we certainly need to speed up our work in that area. Just one example, one sectorial example, ICT, where again, most of the healthy economies spend at least 10% of their public procurement on ICT enabled solutions. The EU here is continuing to lag behind. We can go to the next slide. Now, this topic, the topic of innovation procurement, has been elevated, catapulted to the level of the political discussions about 2 years ago with the adoption of the new European Innovation Agenda, which already foresaw quite some measures and political push for the take-up of innovation procurement. We first wanted to see how the EU can support its member states in actually designing the policies better. That's probably a first step. If you have the well-designed policies at the regional, at national level, then the actual procurement decisions are more likely to follow. But we also need to support that kind of policy change with robust data. Robust data which allows us to benchmark, to compare how our member states are doing in terms of innovation procurement. I shall say very honestly that the measures foreseen 2-3 years ago have been rather marginal in terms of their impact. We have managed to increase the share of innovation procurement from maybe 10 to 11% of total procurement spending. Clearly, we need to do more. We can go to the next slide, where you see that this year in particular, rather last year, 2024, there has been a known and a re-strengthened push for stronger action. There have been a number of very valuable reports which shaped the political thinking at the EU level. The reports of former Italian prime ministers Draghi and Letta, all pointing to the importance of having more innovation procurement in Europe. The 300 billion euro figure that is floating around as the current figure for innovation procurement needs to be doubled. This would be almost as much as the total funding that the EU spends on development of regions over a 7-year period under the current multi-annual financial framework. This would give a very, very significant boost to the economy. Now, these reports have also identified already a number of restrictions, obstacles, which may explain why innovation procurement is still lagging behind. You see many of those on the screen, but I think all this just underlines why we have asked a group of experts to investigate how these barriers can be actually overcome. And this brings us to the purpose of the discussion and the meeting today. We really are looking forward to hearing from you and hearing from the experts. What are the possible solutions that you would suggest for overcoming these barriers? Importantly, we will have essentially 2 avenues to make these potential changes happen. We can go to the last slide of my presentation, which helps you understand the political decision-making process and where the ideas that we will be discussing today can be channeled in. So the main political push came from the competitiveness compass, which charts the way for the Commission for the years ahead on how to boost Europe's competitiveness. The first pillar, the number 1 pillar of that major competitiveness program is closing the innovation gap. And within that priority area, there is a will to more significantly and speedily bring research results to the market. And that is where, in particular, innovation procurement can help play its role. Now, the 3 main policy documents that you can influence and where we would want to see a strong push for innovation procurement and for measures to remove obstacles to innovation procurement are in the little box on this slide. First and foremost, the revision of the public procurement directives themselves. So there we need to see if there are rules in the public procurement directives which may need to be adjusted, or if new rules would need to be added in favor of innovation procurement. You should know that the consultation on that revision process is now ongoing, with a deadline of 7th of March to propose changes, adjustments to the public procurement rules. In parallel, we have just launched earlier this week, on the 17th of February, a consultation on the EU Startup Scale-Up Strategy. So this is a vast strategic document which will look at many things, not only innovation procurement, not only procurement. It is about all potential hurdles that startups and scale-ups are facing currently in the EU, from access to markets, through access to talents, to access to infrastructure. But obviously, the participation or rather the low participation of startups and scale-ups in innovation procurement is going to be one important angle that we will look at in the startup and scale-up strategy. So on that, the consultation will be running until the 17th of March. A bit more time to still have your say. And then finally, it will follow a bit later, the EU Innovation Act, the European Innovation Act, which will try to translate into legal action some of the measures that we will include in the startup scale-up strategy. Again, this is not limited to innovation procurement. We will be looking at access to technology or research infrastructures. We will be looking at regulatory sandboxes as well. But certainly innovation procurement and any legislative measures which may need to be taken to promote innovation procurement are going to be carefully assessed in the EU Innovation Act itself as well. So just to sum up, the timing is absolutely ripe for the discussion today, and we will be very carefully taking notes already of the meeting today. I will not be able to stay on, unfortunately, for the rest of the event. Lieve Bos, our innovation procurement expert from my team, will be with you, but we will be very carefully looking at the discussion today and how it can shape those policy initiatives that I have highlighted in the presentation today. So thank you very much, and have a great webinar for the rest of the morning.
Mr. Inutha, I thank you very much for the overview of the policies, and also to see how we as citizens and experts can help in order to improve the rules and regulations from an EU perspective. So that, of course, that's always appreciated. In the meantime, we already received some questions, but that's more regarding background information. So we ensure that in the Q&A document, we will follow that up. But for now, Mr. Inutha, thank you very much, and talk to you soon. Thank you very much. Okay, after this overview, we will start with the preliminary key findings from the group of experts that have investigated legal barriers and ways to overcome them. Before we do that, I would like to give the floor to Lieve Bos. Lieve, I think you're there already.
Yes, I'm here.
Okay, the floor is yours.
Okay, let's have a look at what the experts were supposed to do, the methodology they were asked to follow. So if we go to the next slide, what we'll be looking at, of course, we look first at what is the scope and the objective of their work. I'll explain to you also who were the experts that were involved. And then the experts will continue with what are the main findings, the results, what are the barriers that they identified, possible solutions, and any other interesting measures, for example, from other parts of the world that we could look at to learn from. Just keep in mind that we're presenting this to you now as stakeholders. It's the first time that all these experts bring all their knowledge together from all the different countries they analyze. So if you see somewhere something that is missing that you think should be added, you have any comments, let us know. The experts will continue to work on this assignment until April, so we still have time to take into account your comments. If we go to the next slide, we start with the scope and the objectives. So first of all, we wanted to understand how can we foster innovation procurement better through legal framework. So the experts had to identify, first of all, how are the current national legal frameworks of all the different countries around Europe and the EU legal framework fostering innovation procurement today in comparison with other leading economies around the world. Because if we want to make Europe as competitive as other economies around the world, we need to know what they are doing, especially if they're doing things that we can learn from. Secondly, exploring measures to fix the obstacles. And even in places where there are no obstacles, are there maybe additional techniques that are already allowed to be used in our legal framework, but that are not used enough, because maybe the legal framework does not explain well enough how you can use these techniques yet, or there is not enough legal push to do it. So finally, the experts were asked also to come with recommendations. What could be legal measures to boost more innovation procurement in Europe? Why are we doing this assignment was already mentioned in the context of all these new political initiatives, but concretely the contracts are expert contracts with a number of experts to advise our European Innovation Council Forum. What is that? That's a forum that the European Commission has to discuss with all member states and also associated countries about how can we improve both national and EU policies to foster innovation. And in there is a working group on innovation procurement. So we are also, with this work, this expert work, the experts are also advising this forum. If we go to the next slide, you can see the experts that were involved. So we have procurement experts from every country, all the EU member states, 27 EU member states, plus also additional countries around the world, such as the UK, the USA, Canada, South Korea, and Japan. And the contacts with the experts on China are still being established. That goes a bit slower, but that work is also going to happen. If we go to the next slide, what can you expect in the report that the experts will ultimately also produce? It's going to tackle the issues that we ask them to look at, of course, like starting with number one, what is the current situation, legal situation in all the different countries, the laws that exist, any legal reforms that are upcoming, what are the main challenges with this current situation, why is innovation procurement underused, what are the problems that buyers and companies face, is there any relevant case law that we should take into account that we can learn from? And then what are your recommendations for possible solutions to address issues at national level and at EU level? On the next slide, you can see this in more detail, the actual questions that each of the experts were asked, so that we get comparable results from all of the experts and we can see what different countries are doing. So on current situation, they were asked, look at any policy legislation, even if it's outside of the public procurement law, that policymakers are using in different countries to push innovation procurement forward. It's typically often legislation in innovation law. And then the primary legal framework, of course, the public procurement legal framework, but also guidance documents related to public procurement, standard government contracts, clauses. And then to look, are there any gaps in those? Are there specific measures that they have to facilitate access of startups and small companies? Are there any legal reforms upcoming? What are the main challenges in terms of innovation procurement techniques that are not used and why? What are the problems that both the buyers and the companies face in the current situation? The relevant case law, what is the most important case law in general, but also on specific techniques that can foster innovation procurement? Is there any case law on that? What can we learn from that? What can be possible solutions at national level to fix the problems in terms of legal measures that could be taken even today, quickly? And then what could be possible measures to stimulate innovation procurement further from the EU level through all these new policy initiatives that are upcoming? Is it currently a framework clear enough? Are there new techniques or mechanisms that we should foster more? Are there parts of the current procedures or mechanisms that should be improved? What can we learn from other jurisdictions in terms of legal measures? So if we continue to the next slide, this is the kind of information you will get from the experts. I will not go over it in detail, but in terms of challenges, they look at specific aspects like, for example, is there an IPR-friendly intellectual property rights regime, yes or no? Is there maybe, why is it, if it's not implemented enough, why is it happening? Is it because there is a lack of legal certainty on how to use it? Is it because there is an insufficient legal push in the current legal framework to use these specific techniques? Is it because the techniques that are available in the current legal framework are maybe too complex to use? And is it maybe because there are barriers for specific actors like small companies to actually even enter the legal framework? And they will come with legal measures on what they think would be improved. But it's better that the experts explain this themselves. So I give the floor back to Stefan. to take you through the barriers and the solutions.
Thank you, Lieve, for this overview of the methodology and the experts. And before we start, I really would like to say thank you to all the experts involved. We have done a massive load of work and we still continue doing that. So thank you for all the great work that has been done until now. For now, I would like to pass the floor to Anna. I think well known to everyone. Anna, the floor is yours.
Thank you very much, Stefan. Good morning to all of you. It's a pleasure to be here in this webinar today. And well, as part of the methodology, we identify some barriers and possible solutions. In this regard, there have been collected some barriers over the past years from innovators that were struggling to bring their innovations into the public procurement market. And based on these barriers, we're thinking also to these measures that can be instrumental to scale up the innovation procurement more widely in Europe. So if we go to the next slide, we will see the different aspects, starting with the policy, having an action plan, having a target, having a definition. And here you see that we are comparing the EU approach and also the approach in the United States, which is one of the front runners in terms of innovation procurement. So in terms of the policy action plan, ideally, well, the innovation procurement is anchored in the rules of procurement to contribute to innovation, to modernize the public services and boost industrial growth. It's important to introduce in the legislation that no public procurement can ever block innovation, so that procurements contribute to innovation where it's possible. And this needs to be clear and agreed by all in terms of the definition of innovation procurement. And also the European Union Innovation Act should create an EU action plan, an EU target for innovation procurement, calling the member states to adopt national action plans with ambitious targets, timeline, and monitoring systems. If we look at the US, we see that there's a clear policy that public procurement must contribute to innovation and commercialization, which drives the public procurement rules. That is the case of the Federal Acquisition Regulation. So in the EU approach, as mentioned before, the EU benchmarking is tracking the progress on national innovation procurement policy frameworks and investments in the different member states, but there's still more to do at national level and also European level. So that's the aim. If we look at the United States, we see from the findings that there's a new proposal. There's a recent US proposal that needs to spur or aim to spur more innovation in the broader federal procurement framework. That's the case of the proposal of Senator Rogers Vickers that aims to increase the efficiency and innovation of the Department of Defense and has 5 specific measures trying to cut red tape, streamlining cost audits and reporting requirements, also unleashing the American innovation, so reducing the procurement of solutions exclusively developed for or provided to the Department of Defense by more commercial solutions that are sold widely on the market, create competitive pressure, enable decisive action, and modernizing the defense budgeting. And so these are some of the elements of this new proposal. You'll be able to learn more details later on. If we go to the other identified barrier or also measure that could be implemented is the possibility to have findable innovation procurement business opportunities so that innovators are enabled to easily find procurement business opportunities and grow their businesses. So it's important that the public buyers publish contract notices or use the prior information notice to announce both market consultations and tenders, already indicating or labeling it as innovative or looking for innovative solutions. So the idea is to recommend member states to adopt these type of measures to boost these possibilities to find opportunity. As an example, in Japan, there is a more transparent publication of innovation procurements in a portal, and in the European approach, there is available the possibility to publish notices like the prior information notice on TED to announce market consultations, but we see from the practice that even though the possibilities there and many of the legislations include preliminary market consultations, not all of are using this type of publications. So these are techniques that are still underutilized and that could be improved. The third aspect relates to the administrative formalities. So too many formalities, especially for small companies. So suggests that no more companies' offers shall be ever disqualified purely on administrative formalities when they have technically the best offer. So it would be possible to correct, modify things that are merely small errors, for example. And also require the buyer to allow the bidder with the best technical offer to regularize these omissions and give clarifications. Another suggestion, another important measure would be to set up a pre-qualification portal with once only automatic collection of administrative forms for all the process at European Union level. At the moment in the EU approach, as you see in Article 55, it's not mandatory for public buyers to first evaluate the technical offer and only then the administrative formalities. As we will see also in the analysis in the different member states, we see that this approach is also underutilized. And normally the approach is too strict, not allowing corrections or clarifying certain small mistakes. In the case of the US, we have a different approach in the terms of it's possible to evaluate the offers, the technical offers first. It's possible also to have specific modifications of minor informalities or irregularities in the bid. In the case of Japan, they try to avoid requiring administrative documents for the selection exclusive criteria, so the relevant ministry provides official documents for them. Going back to number 4, regarding the professional technical qualification, it would be good that no more companies' offers shall ever be disqualified purely based on professional experience or technical capacity, especially for those innovative companies, especially in cases of research and development. So the measure would be limit the disqualification of bidders solely on the basis of lack of performance history to special cases where bidder needs to have unusual professional experience or specialized facilities. In the European approach, in Article 58, we see the reference to technical and professional ability. The directive set no limits to prevent buyers from setting disproportionately high requirements. Bidders can be disqualified solely based on the lack of performance history. So this could be also improved. If we look at the example or the approach in the United States and the Federal Acquisition Regulation, bidders cannot be considered ineligible solely based on lack of performance history unless unusual professional experience or specialized facilities are needed. And in terms of the use of past performance, this should be an important element of every evaluation, but for the award of commercial products and commercial services. In the case of Japan, there's also flexibility in allowing startups to prove their track record. In number 5, we look at the unfair financial restrictions. So banning unfair restrictions in terms of financial restrictions on companies that jeopardize their participation in public procurement needs to be fixed. Asking for disproportionate requirements on the track record, on the turnover, can be improved so that the companies can participate. If we look at the approach in the United States, in the Federal Acquisition Regulation, we see that indeed a prospective contractor must have adequate financial resources to perform the contract, or the ability to obtain them, but there's also the flexibility for those contractors that do not have financial capacity to prove by other means that they can actually implement or deliver work, services, etc. Federal acquisition regulation also has some requirements or provisions on the financial protections and insurance, and defines maximum limits for financial guarantees and indemnity insurance coverage for different type of contracts. So it really is linked to the type of contracts so that it's prevented to set these disproportionate requirements. Also in Japan, we see that there's flexibility in allowing startups to prove their track record, as we see. In the European approach, we mentioned already Article 58, and still some measures that could be implemented so that procurers do not set disproportionate selection criteria. This still happens in practice, even though there is guidance to help procurers identify that it is important to give the possibility to have other proof of their means of proof especially to small companies. We go to next one. I think I pass one. There's number 6 related to too many price-only base award. So it is important to look at the value for money aspects, value for money award criteria. So make it a norm to evaluate offers not only on price, but also on quality, unless there is no variation in quality, let's say, for between products from different vendors, like standard products. But make it mandatory for strategic procurements, for example, for green innovation type procurements, social related to social innovation, social aspects, also in critical and strategic technologies. And also make it a norm to take into account the total cost of ownership. So looking at the long-term benefits of the procured solutions in the evaluation of offers. In the European approach at the moment, in Article 67, we have the economical most advantageous tendering that includes also buying based on lowest price only. There's not a specific preference on pushing or taking quality into account. And this also needs to be an important measure. We look at the US approach. The lowest price technically is acceptable, but it has to be justified. That means that there are 6 mandatory conditions that need satisfied to use the lowest price only award criteria. And this also requires a written justification in the tender documents. But there's also a provision to use the price only award criteria for specific procurement in sensitive sectors and in strategic technology fields that could be, for example, information technology, cybersecurity, knowledge-based training, healthcare services, to give you an example. Let's go now to this next slide, the over-specification of tender aspects. So in this regard, it is really important that more attention is given to the definition of specs from a as functional requirements from a functional perspective, ensuring that these tenders do not exclude a priori certain offers, and are not over-specified based on well-known established solutions, and make it the norm that public buyers, procurers, write non-prescriptive functional performance-based tender specifications. And when it is feasible, and also possible allow companies to submit parent offers. In the European approach, we look at Preamble 74. It is already mentioned trying to foster the use of functional and performance-based specifications that are best suited for competition and also for innovation. But Article 42 does not push for this to be the preferred approach over solution prescriptive tender documents. So there's still cases in which public buyers over-specify the tender specs in Europe. If you look at the European, the approach in the United States in comparison with the European approach, we see in the Federal Acquisition Regulation that the agencies need to describe their needs and need to describe in order of preference the documents mandated for use by law. But in second place, the performance-oriented documents, also detailed design-oriented documents, and to it is also required that to the maximum extent practicable, the procurers use functional specifications, performance is required, and there's also interesting case law in this regard. Let's go moving a little further because we are on time. So we go to the next slide. We see also that Japan is trying to minimize the overspecification, and the government has adopted voluntary measures in order to do that. Now to the next slide. We go to the number 8. So we need also incentives to innovate in ongoing contracts. And how do we propose to do that? For example, to implement as good practice the use of value engineering change proposals. So value engineering clauses that allow for improvements during the term of the contract. And the directives also already provide guidance on the modification of contracts. But it is important that more public procurers use these techniques. If you look at the approach in the United States, value engineering has been used for a long time. There's the budget circular from the Executive Office of the President that is encouraging value engineering. There are also several clauses already in the Federal Acquisition Regulation. And we'll go to the next slide. We'll see that in Japan, there's a use of value engineering. We have some statistic that was provided by the expert who gave us information. We see that in 88.6% of the entities, they have not yet used value engineering, but the interesting thing is that the other percentage are using these techniques, especially the ministries, the public, special public entities, prefectures, designated cities, and municipalities. Next slide. Regarding the friendly allocation of IPR, the IPR regime, well, the measure would be that no more intellectual property rights handling unjustifiably block companies from protecting and commercializing their innovations. So it would be important to require that for all procurements, public procurements, the tender documents specify the distribution of intellectual property rights and the obligations in line with the applicable IPR, copyright, and trade secret law. The US approach, we have a really interesting experience already for a long time with the Veto Act that ensures that the government adopts as default regime in all its public procurements to leave the IPR ownership to the contractors. Go to the next slide due to the time. Going to slide 10. Let me see. And this is a measure related to multiple sourcing, the importance of having alternative possibilities in the procurement, so public procurers have an easy way to give the same assignment to multiple companies in every procurement procedure, beyond more complex systems like in the framework contracts or dynamic purchasing systems. So allow in every procurement to have best offers in plural based on the rank list. We see this approach in the Federal Acquisition Regulation, and also we compare it to the approach in the European Union in Article 67. When it refers to the contract award, it only allows to award one contract to the tenderer with the best offer, but multiple sourcing only possible, working around with more complex systems like I mentioned before. So this is something that needs to be improved. Regarding a strategic autonomy, there needs to be some clear legal provisions on how public procurers can reinforce the strategic autonomy of Europe, setting some minimal mandatory provisions to safeguard the minimum level of strategic autonomy. We see this approach in the United States, especially in all R&D procurements, where the contracts are awarded only to US established companies, and the majority of R&D must be performed in the United States. And well, we have several measures in order to have this possibility. In comparison, the directives do not provide a legal certainty or clear clauses in this regard. Then we go to joint cross-border procurement. The measure that would be suggested would be to create this 28th regime that a public buyer in any EU country can use to launch joint procurement together with other public buyers from other European countries. Of course, this is difficult due to the difference in the transposition of the existing procurement directives, but it is possible. This is some measure that needs to be improved in the future. And then we have the importance to facilitate the participation of startups and SMEs, trying to cut this red tape that, for example, brings slow decisions, slow payments, and especially for small and medium enterprises and subcontractors. So with the measures could be to define a maximum deadline for the buyer to evaluate offers, to do this fast publication of the preliminary rankings, use advance payments or accelerate payments, and also use documents that are published in machine readable format, so that it's easier for the companies to process them and also to present their offers. We see that these approaches are used in the United States, and in the case of the European Union, these points are not forbidden, but there's still not enough encouragement to apply them. In the case of Japan, we see that there are measures for being more friendly with startups in the procurement. Look at the Act on Promotion of Science and Technology, or the Basic Plan for Science and Innovation. There's also some guidance for policies that are promoting procurement from startups, so that ministries launch lighthouse innovation procurements with more transparent publication of procurements, and also with the info days and trainings for the startups, etc. So, well, based on the methodology that Live has described, we ask the different experts to provide us information about the gaps in the legal framework, and we identify these 16 gaps related also to these barriers that we have mentioned before, on the publication of market consultations, the use of the innovation label in the publications, etc. And this is just a preliminary view of how we have identified when there is a gap, when there's already measures, or no gap. So the good thing is that you see a lot of green also in this map. So that means that there is legislation that is opening the possibility to implement market consultations, to implement value for money award criteria. What we see is that there's no common definition of innovation procurement in all of the member states, even though there are definitions, for example, on research and development or pre-commercial procurement. But yeah, we pass it. It's just to give you an initial view of this dashboard, and also relate the dashboard in relation to the specific legislation to improve the participation of innovative SMEs. So there are initiatives in some of the countries. They are also pushing with new measures and guidance, but there's still some gaps, specifically on those aspects that we mentioned before. And with that, give the floor to Stefan. Thank you so much.
Thank you, Anna. We're a little bit behind schedule, but thank you for the great overview. And I can imagine that you all would love to dive into the nice overview and the chart. But as stated, the document can be downloaded, and we make it available to everyone, so then you can look into all the material. For now, I would like to start with the country analysis presented by Mark Martens from Bird & Bird. Mark, the floor is yours, so to say.
Many thanks, Stefan. Can you hear me?
Yes, we can.
Excellent. Well, first of all, many thanks to you for this nice presentation. Many thanks also to Lieve and Anna for having putting the scene, in a certain sense, of the methodology that we have used for the review and the assessment. And also to provide us already with the few and the most predominant issues that we have encountered and that we are encountering in Europe with regard to the increasing of innovation in public procurement. Now, what I'm going to do during this presentation is to give you a flavor of the assessment that Bird has done in 12 different countries: Belgium, Denmark, Finland, France, Germany, Hungary, Ireland, Italy, Poland, Spain, Sweden, and the UK. And my presentation will be divided in 5 parts, which are predominantly a copy, in a certain sense, of the content of the thorough report that we have done according to the methodology that was imposed to us for all these countries. So I'll start with highlighting some gaps in the different legal regimes, 4 or 5 big families of issues that are systematically encountered or differentiated in between the member states. We will then dig into something which really occurred, and that's also something that Anna has highlighted. It's the underutilization of certain obvious legal techniques that are already available through the legal framework in Europe, but that are, for many different reasons, underutilized by the member states. We will then, in a third part, dig into the SME participation. What are the challenges for SMEs? What are the measures that we can take to increase the intake of SMEs within these INPROs, the innovation procurement? I'll dig into case law in 5 different member states that may be of relevance or interesting to see what's and how the courts are assessing the improved flexibility mechanisms that we try to put in place in certain jurisdictions. And then we'll dig into proposed solutions to increase the innovation procurement from a qualitative and from a quantitative perspective in the different member states. We'll go into IPR questions that have already been highlighted until now, but also in general remarks on how promoting more generally the innovation procurement. So let's dive into the next slide, please. Yes, that's it. So let's dive into the highlights that I can show with regard to gaps in the legal frameworks in the 12 jurisdictions that we have addressed. So the first one is the fact that many legislations do not specifically encourage the use of innovation-friendly allocation of IP rights to the contracting parties, to the SMEs, for instance, while performing the contract. There is one exception for once in the situation, whereas in most and all of the countries that we have reviewed, there was no specific provision imposing, for instance, or creating a system by default that the IPRs would be remain or allocated to the contracting party in order to foster innovation. There is one exception in Belgium, even though the implementing law of Directive 2014/24 does leave a broad discretion to the contracting authority to decide whether the allocation of the IPR would be to the contracting authority or to the contracting party. There is a royal decree that puts a default system, especially for SMEs, to the contracting party, and that's very, very positive in a certain sense, and has shown already that the facility to increase innovation procurement has been increased by that measure, because there is no need of specific justifications of the reasons, of motivation, of providing the statement of reasons of why we would leave or allocate the IPR rights within the contracting party. Other issue is the fact that there is no definition, clear definition about innovation procurement and R&D procurement. You see that is an issue in all of the reviewed member states. Additional point is that there is no encouragement nor legal requirement to opt for a value for money award criteria system versus the lowest price only on criterion in several member states. But we see, and that's the positive thing of it, that in some member states it is possible. Now, Germany and Belgium, for instance, did not use the possibility left by Article 67.23 of Directive 2014/24 that allows member states to provide that contracting authority will not use price or cost or only in certain circumstances for specific contracts or limited to certain contracting authorities. That has not been optioned by the Germany and the German and the Belgian state. But in other countries, there are alternative solutions to that. For instance, in Hungary, the law requires the use of the best value for money evaluation criteria, and the lowest price criteria may be used as the sole evaluation criteria only in limited cases where the needs of the competent and contracting authority can be satisfied only buy goods or services which comply with very and strict specific quality and technical requirements, and solely the lowest price serves the purpose of selecting that. In the UK, it's not in hard law written as such, but in many guidance documents, as for instance, the managing public money guidance document, value for money is a central principle for this guidance. In Spain, for instance, there is a general rule: the award is required to be based on value on money criteria, and only in exceptional circumstances, the award can be cost-based only, and this must be justified. So really the reversement of the obligation. In Finland, and that's an interesting legislation too, in certain cases, the contracting entity may change the order of the ranking they made based on the lowest price if it receives a proposal that proposes an innovative solution of exceptionally high quality or high standards with respect to functional performance. But then, and that's an application of a general principle in public procurement, they have to relaunch a new call for tenders. You have to put it back into competition. But the possibility to not to grant the contract after having assessed the different bids is a possibility that is open in most of the member states. In this case, it is even a little bit clarified in the sense that if you're confronted with innovation in certain circumstances, well, from a lowest price system, you can relaunch a contract based on other criteria. In Poland, contracting authority can only use the price criterion with a weight exceeding 60% if they specify that in the description of the tender documentations and justify that also with statement of reasons. And in Italy, lately, the award criteria listed in Article 108.2 of the Italian Public Procurement Code do require the use of value for money criteria in connection with supply and services procurement that have an innovative context. So we see that even though some more orthodox conceptions of public procurement are still not pushing that forward, there is a tendency in many member states really to open the possibility to go for value for money criteria instead of price only. Other gap that we identified is the national language restrictions. In Spain, in Italy, and in Belgium, particularly strict laws with regards to the use of languages in administrative situations are particularly severe and hamper also the possibility to a further harmonization of the market in a certain sense. So this gap is transcending in a certain sense the innovation procurement question, because it's also a hampering for broader contracts. Value engineering is not regulated nor encouraged in all the member states that we have reviewed, and there are no heightened transparency requirements for innovation procurement unless in Ireland and in Hungary, where there is an obligation to mention that, or in the notice documents, standard contract notices, or in the PIN as far as Hungary is concerned, but not for the other ones. Next slide, please. This brings us to the underutilized legal techniques. And I think that is really one of the important aspects of our review, that is that since the directives of 2014, several flexibility mechanisms have been introduced in the directives and could be implemented in national law, but we see that several of them still lacks integration really in the day-to-day practices of the contracting authorities. First example is the underuse of the flexible instruments like innovation partnership or competitive dialogue. And the reasons for the underuse in the UK, for instance, it's bad reputation. In the preliminary implementation phase of these new rules in 2014, when the UK was still part of the European Union, there were a few issues with regard to contracts passed through these competitive dialogues, very expensive contracts, very long-term, and has created a very high mistrust of the competent authorities with regards to the use of these techniques. In Germany, for instance, the best practices are lacking, or the risks and requirements are considered to be too high. In Sweden, they highlighted that due to the perceived complexity and uncertainty about the process, it's not used and adhered to very strongly. And in France, again, risks are highlighted as being one of the reasons why these practices are not implemented a lot. So we really feel it's the perception and the mistrust of contracting authority themselves with regard to these techniques that are mostly at the origin of the lack of adherence to these new techniques within the directives, which is sad. And there are several means that we can imagine that could try to change that behavior of contracting authority and go in the other directions. And I think guidance, expertise, and support to contracting authority to test them out, sharing of experiences could be one of the solutions given to these lacks. Another one, and that's one very near my heart, and it's the underuse of market consultations. Now, the reasons given for the underuse of market consultation slides in Sweden, for instance, was highlighted that there was a lack of resources or expertise to conduct thorough market research. In Italy, market consultations are used to restrict participation to tender to one procurer. So it is a perverse effect in a certain sense of market consultations. Market consultations are only used in not even 1% of the procedure in Spain and not even 2% in Poland. And I think market consultations are really kind of a symptom of issues that we encounter with innovation procurement, and that is that there is a gap within the administrations, within the contracting authorities, in between the identification of the needs they want to be fulfilled through the public procurement and the understanding and expertise they have with regard to the possible solutions given that would fulfill these needs. It is only if public servants and the contracting authority will understand the possibilities given by the differentiated solutions that can be given by the market to certain needs of these contracting authority, that they will be able to open the definition of the needs, the subject matter of the contract, in such a way to allow competition of different types of solutions for the need to be fulfilled. And one of the ways to really overcome that burden of lack of expertise lies in market consultations. It is really critical that the civil servants and the contracting authorities understand what they're trying to buy, and to do so they have really to inform themselves, and one of the ways to do that is through market consultations. Next slide, please. So this brings us to the SME participation to innovation procurement. I have two slides on that, one identifying the challenges of SMEs and another one identifying possible solutions to it. One of the issues with regard to the SMEs lies in what Anna highlighted in her presentations as being administrative requirements to enter into public procurements, and the lack of historically and financial credentials are an issue in 5 countries of the 12 that we have studied during the research. Belgium has made a research and an assessment, an audit on reasons why SMEs had so much difficulties to be included more intensely into public procurements, and identified that smaller companies were really frustrated by the obligation to provide a statement of turnover and require minimal level of turnover. This is really an issue, especially for small companies, and a way to overcome that is to form consortia with other ones and to try to globalize the turnover issues, but that remains a big issue. Questions with regard to bank statements, questions with regard to the reference list of previous achievements and procurements performed is really an issue, especially for startup and smaller companies. So we should find ways for contracting authority to have substantially more flexibility in opening the access of public procurement to these kinds of contracting parties without taking unnecessary risk, because of course these technical specifications and requirements are there to protect, in a certain sense, the possibilities and the public procurement, and especially to protect the contracting authorities. So there is a risk. A challenge that we identified for SMEs is the risk aversion of public buyers. That's linked to the previous one also. The complexity and rigor of procurement proceedings, if you have seen that. It's complex. It's not only complex for smaller companies, but also for bigger companies, but especially also for contracting authorities themselves, especially for smaller contracting authorities. The lack of financial buffer to manage cash flow during the procurement process is a big issue for SMEs. And that specifically, and I don't even speak about advances possibly, but that's specifically now that we know that some countries are known to be bad payers. France, Belgium are known to be bad payers. In Belgium, for instance, the Court of Auditors, the Rekenhof, the Cour des Comptes, has made a research 2 years ago and discovered that half of the federal procurers exceed payments deadlines without paying interest. Half of them. If you're an SME with limited cash flow capacity and that you're performing and that 50 or 60% of your capacity of working forces are on a public procurement and that they're not paying, you have an issue. You have a critical issue. In Germany, the issue is also highlighted, and public authorities are often too slow in their decisions, and payment periods are often too long within the contracting documents themselves. So we see that's really critical. The financial part and support and infrastructure for the SMEs is really a critical one. Other one issue that we identified is the fact that the IPR, even though in certain regimes, like in Belgium, for instance, there is a possibility and there is a default system where the IPR remains within the contracting parties or is allocated to them, contracting authority do not apply that and still requires the allocation of these IPR rights to the contracting authority. That is also an identified issue with regards to the fostering of the innovation procurement. And then the overly restrictive financial requirements, such as guarantees and insurances, are also possible hurdles for SMEs to participate to these contracts. Next slide, please. So on the more positive side, we tried also to identify legislations, measures, guidance that makes innovation procurement easier in a certain sense for SMEs. Early publication of the preliminary ranking of the bidders immediately after the opening of the offers is encouraged in many legislations. Mandatory payments by public authority within 30 calendar days is also mentioned in 3 countries, even though in Belgium we know that even though the law provides it, it's not respected in many cases. Possibility to give financial compensation to SMEs to participate to the public procurement, to all participants, is something which is provided for in Sweden and the UK. And that's interesting. The regulation 3021 of the PCR 2015 in the UK allows for contracting authorities to specify prices and payments to participants. This could also provide financial compensation. In Finland, in innovation partnerships, contracting authorities shall provide payments of compensation for the research and innovation process. That's Article 39. So we see that in some member states, provisions exist to facilitate that. We may consider trying to put that more in the spotlight and convince other member states also to go in that direction. Other one is the procurement documents can only refer to documents that are available free of charge. In many countries, it's a practice, but in some countries, there are still remunerations requirements in this regard. An additional, which is very interesting, is that the legislation may provide obligation to advance payments to SMEs contractors in certain circumstances. It's the case for France, for instance, where state contracts since December 2018 should be subject to an advance amount that has been increased to 20% if the contractor or its subcontractor is an SME. In Belgium, we have a comparable system going from 15% to 20% for micro enterprises, and even up to 50% of the contract value when we're confronted with R&D for prototypes, for instance. So we see that member states, once they use the flexibility given by the directives to push forward and to support additionally SMEs in R&D, it is an open way to do it. This provision has not been challenged and is used quite regularly. I've had an example in a recent contract in Belgium. There is, like in Italy, the possibility to have a minimal requirement of subcontractors reserved to SMEs. Another example is the flexibility to prove the economic and financial standing for companies created less than 3 years ago. because often requirements are put as you have to provide certain levels and thresholds of turnover the last 3 years. But for many companies and startup companies which are just created or which are under building, they're just not finalized yet, it's sometimes very difficult to even be able to file an offer if the company is still in implementation phase. So that's what concerns the SMEs. I propose now to dig into the next slide with regard to a few cases that I would like to highlight that we have been confronted with in some of the member states subject to our review. First one is Germany. Lately, a judgment of May 2024 of the Düsseldorf Higher Regional Court decided that when there is a company that has already advised or supported the contracting authority in the preliminary stages of the procurement, the selection and award criteria must be formulated in such a neutral way that no evaluation advantages arise from any knowledge advantage of the preoccupied company. This is kind of an German application of the Fabricom case of the European Court of Justice, but it's very important to stress and to remind contracting authority that in fact companies that participate to the preparations, to the finding, to the identifications and clarifications of different solutions, and to help the contracting authority to clarify its needs, does not hamper that company to ultimately participate to the subsequent contract procedure that would be launched after it. The only requirements, of course, is that competition should be preserved and that no information should remain within that company that would be critical for the granting of the contract and that would be not communicated to the other competitors. In Spain, another interesting court decision, it's the court itself that stressed the advisability of revising the legal framework. So the court, the Central Administrative Court of Appeal, mentioned in one of its judgments that it would be a good idea for the legislature to review its copy in order to adapt the legal framework to the need to obtain greater flexibility to boost sectors such as research and development, as occurs in the Anglo-Saxon legal system, in which it is possible to maintain full ownership of these rights in the contracting company. So the case law itself pushes the legislator in a certain sense to bring more flexibility with regard to IPR rights. Another one, and that's the downside of it, is in Finland, where we were confronted with the annulment of a procurement decision for an innovation partnership due because the comparative data for the best value for money were not indicated in the contract notice or in other contract documents made available at the time of the publications, and they had to relaunch the contracts award. So that's a critical part of it, because in many innovation procurement, it's quite difficult to have, and it's quite technical to put the right award criteria that would allow the operators to have sufficient flexibility to come up with their own original solution, in a certain sense, in a way that it would still allow contracting authority to compare the different solutions. And that's really a critical one. You could be confronted with one solution that would just improve the software, whereas another solution would just come up with the new hardware. How would you compare that? There are many functional requirements and criteria that could help contracting authority to find an answer to that question. But we see that sometimes the lack of expertise, probably, of contracting authority to finally and duly shape the award criteria in such a way to permit competition and transparent competition in an equal treatment, but still to allow big differences in between the solutions provided by the operators. I will go to the next slide, please, because I see that the time is running. And I'll dig into several proposed solutions at national level that have been proposed by our experts regarding the allocation of intellectual property rights. They all go in the direction of please allow a system whereby the contractors could, one or the other way, remain or keep the IPR rights with regard to the inventions they would have. In Sweden and Germany, they propose to adopt a default regime like we have in Belgium to leave the ownership of intellectual property with the technology provider, unless in exceptional cases where the contracting authority has justified reasons why it shouldn't. In other countries, they propose to develop a guidance document on the benefits of leaving the ownership of IPRs with the suppliers and retaining the rights. Or in the UK, to include case studies or example scenarios in which these options could be used. In Denmark, they propose that the contractor keeps the IPR but grants extensive usage rights, not only for the contracting authority itself, but also for any current and future other contractors working for the contracting authority. Now, IPR is a sensitive part of it, because what we see out of the experience we have also in pre-commercial procurements, for instance, but also in innovation procurement, is the danger of vendor lock. If you relieve the IPR within the contracting operators, you must be sure that in the long term, you would not, as a contracting authority, you would not be in a situation where you pay twice, one for the development of the solution in an innovation procurement, and the second time, ultimately later, for other public procurements, where the final and fully furbished product will be on the market and will be sold again to the contracting authority. So it's a paradox that has to be fine-tuned, but there are many means to find a solution for that. Next slide, please. Other proposed national measures on various topics are the following one. In Finland, they proposed compensative payments with guidance to encourage contracting entities to utilize that compensation for SMEs or in public procurement processes for innovation, really to attract operators to participate to these projects. Italy, Spain, and Germany asks for a development of guidance on how contracting authority must carry out the preparatory activities without excluding the entities that participate to these preparatory works, you know, the Fabricom case. Belgium provides or requests for provision of guidelines to discover possibilities to enable variance and to adapt award criteria in that sense. In these guidelines, the concept of value engineering can be introduced to procurers to make them familiar with the concept and the options. Payment measures, a shorter payment deadline was one of the proposals in Hungary. I can add one, for instance, is really to stress the possibility given by the new directives with regard to modifications to the contract's specifications while performing the contract. We really see that in innovation procurements, but also with pre-commercial procurements, it's critical to be able that when you find certain answers to problems in the development of certain solutions, to be able to adapt your contract in a versatile way, allowing ultimately the provider to come up with a better solutions than the one originally provided for. That's really an instrument that is existing already in our systems, but that is insufficiently used by contracting authority. They are really afraid, in a certain sense, to modify too substantially the contract, the original contract, and to open the door for litigations of other competitors that would be discriminated, in a certain sense, by these modifications. So there, I think there is really knowledge, understanding, and promotion to be done about what the possibilities are for contracting authorities to adapt and to modify the contracts. Last slide, please. That brings me to the last slides. And these are probably the most pragmatic and immediately useful suggestions that we formulate with regards to improving innovation procurement on national level. It can be promoted by the creation of standards contracts and catalogs with rights and provision that suits innovation procurement to help contracting authorities to better understand what they can do to have more support in a certain sense. Introducing national funding mechanisms specifically for innovation procurement, that's critical. I mean, funding is probably one of the biggest hurdles, I think, to go for an increased implementation of innovation procurement. development of best practices and examples. These are all instruments that can facilitate the intake by contracting authorities of these techniques. Implementation of comprehensive training programs for contracting authorities, development of dedicated centralized websites for public procurement and innovations. So we see that many tools for innovative public procurement exist, but they are largely underused by contracting authority due to the fear of compromising the security of their contracts, but also sometimes due to the lack of experience of their civil servants. That's, in a nutshell, in a certain sense, the most important points we have highlighted of the review of the 12 member states we have covered. And we thank you very much for your attention.
Thank you, Mark. Due to time, I only have one question for you, Mark, that's fine. There's one question from the audience, so to say, and I think it's a very easy one for you to answer, and that is, what are the sources, what is the evidence for your conclusions and assessments?
So our experts in all the member states base their assessment on existing documentations predominantly, so on the law, gapping, identifying the gaps, on the research made by contracting authority, but by scholars, and our the proper experience. So it's a mixed source review that we did, but I don't think we went too far in the extrapolations that we did with regard to the suggestion to formulate it.
Thank you, Mark. And another question popped up, and I'm unsure if it was discussed. To what extent is public procurement open to cross-border tendering? I mean, among the EU member states?
Well, joint procurement is a critical issue. I'm myself involved for a moment in innovation procurement, in joint procurement. It is really an instrument which exists already in the directives. It's provided for. The operators and the contracting authority of several member states have to identify one member state that will, in a certain sense, be responsible for the proceeding. You have to choose one legal framework, national legal framework applicable. The only issue that I encounter with it, and we have the same issue also with the vaccines contracts, to be honest, is the enforcement of the decisions taken in this regard, especially towards contracting authorities. As a litigator, that is probably one of the biggest issues we have, because of course, if you have several contracting authority of several member states that are all subject to contracts to Belgium law or French law, how are you going to enforce these decisions against this contracting authority? That remains an issue in the level of harmonization that we have in these in the directives for the moment, but that is probably something which is going farther than the subject matter of this conference.
Absolutely. Well, thank you, Mark, and please stay on board, so to say, because I expect a lot of questions at the end of our session. For now, I would like to pass the floor to Davidas. Are you in?
I am. Hello.
Okay. The floor is yours.
Thank you very much, ladies and gentlemen. Thanks for inviting and allowing to have this opportunity to present on the Baltics. I may start with our slides, and we have Lithuania, Latvia, and Estonia. And as other experts, we were engaged into this work with under the specific template. And if we move forward, we see the questions that's been asked, that were asked, and we dig deep into the national practices, legislation, materials, case law of 3 countries, Lithuania, Latvia, and Estonia, together with my team. And here we have not that optimistic view in terms of the practice. I have to say that I will not repeat, the question and the answer. All the listeners and viewers can do by themselves. I want to summarize and provide a few insights. As we all may experience across the EU, I would say that more or less we have the same situation. We have a very modern platform, which allows, if wanted, if mentality was ready, to seek or implement various practices in order to buy innovatively or to buy innovation or to, try to catch up with Silicon Valley or other places where new things from tech or other aspects are born. So the same is in Baltics. If we see Lithuania, Latvia, or Estonia, we have the laws, we have soft law, we have guidelines, we have policies, we have anything you want across different authorities, starting from governments, ending with ministries or fund administrators, saying that they are fostering, cherishing innovation. They are all hands on deck regarding procurement implementation, etc., etc. But when it comes to practice, if I asked how many innovative partnerships have been during the time after the directives were implemented, at least in Lithuania, none. I believe so. It's for the same as for Latvia or Estonia. How many, innovative procurement procedures or something innovative or something highlighted that we might see across these three jurisdictions happened, so to say, in practice, that we might, say that it was done not in the area of venture capitalists, but in the area or in the realm of, let's say, government or EU funding, etc., etc. I don't recall any, very famous or very highlighted case which I can, praise our jurisdictions for. So the insight is that we have the regulation. Some of my teammates say that we lack a few one or another aspects. Let's say we say that no definition for innovation procurement and R&D procurement within the laws, but it's not that very accurate. We have different definitions. It might be that they might be broader ones, or the wish is that they might be broader ones. But overall, the legal ecosystem is good. I think that the problem with these X's that you see on the table is that it's about the mentality. It's about still too few understanding or training on what the innovation is, how it might be accessed and reached, how private sector and real innovators might be tempted by not only venture capitalists or other funds, but the funds that European Union or national budgets may suggest. So we have this table with more negative situation on specific questions which you see. But the message is that it's not a banana jurisdiction, and if we checked the let's say ecosystem from regulation standpoint, I think it's the same as elsewhere in the EU. It's good, and we have many soft, as I've mentioned, laws drafted in order to open or create the platforms which would allow to move on with and forward with innovation procurement once the mentality and ecosystem is ready. Let's go ahead. Another slide, and we say what the techniques are underused. There are, again, the same as was mentioned, the market consultations. I believe that mentality is being created in the dialogue between the ones who really know and who spend daily, routine, and whose daily routine in creating this innovation, with the ones who are administrating funds, or whose routine is the bureaucracy. So it seems that throughout these three jurisdictions, we still lack, this communication. Although by all means, all jurisdictions really know the notion of market consultations, first of all, within the realm of public procurement procedures. But again, if we talked about, and if one asked, when was the last time, David, as you heard something about market consultation on innovation, or on what creators or innovators lack, what they are wishing from, bureaucracy side in order to help them with their ideas, etc., I wouldn't mention any. So at that moment, at least in Lithuania. So this means that this market consultation is, as a tool, is used for the daily public procurement routines and procedures. But when we talk about the innovation, I think it's still underused. The same is innovation related to what criteria. Let's say if we take the jurisdiction where I come from, the Lithuania, we have already mandatory requirements to use meet mostly economically advantageous tenders and offers versus lowest price criteria. I believe 50-50 if I'm correct. But let's say if we check on Latvia, we see that this kind of approach hasn't been taken by the government yet, and only, as far as I remember from my colleagues' report, around 20%, or from the other side, still 80% of procurement is being done on the lowest price. So, which is quite surprising, I would say. So yes, we see that again, the legal background is perfect, superb. We have the directives, we have national laws on meat use as an award criteria, but the practice somehow is still different. Although we have almost, more than 10 years after the directives and almost 10 years after they had been implemented into the national jurisdictions. Why is that? I believe that still
It seems that we have an interruption in the sound. Davidas, are you still there? Okay, I think that we can resume, hopefully. Davidas, are you back?
Yeah, I'm back.
Yeah, okay, you will interrupt it. So you were talking about the underuse of innovation-related award criteria. You're going to finalize this part, so to say.
Yeah, so I wanted, I don't know which part I was cut off from, but my idea was that we have the good ecosystem from the legal standpoint, but still lacking the mentality, which is needed to more use the award criteria oriented towards the innovation procurement. Let's go with the other slide. The same has been mentioned by my colleagues. The previous one, please. The previous one, yeah. The same has been mentioned by my colleagues. Intellectual property rights. I don't know why, but the state is simply still thinks that it's this sovereign, which in almost all cases has to obtain the IPR rights if it spent at least a penny on something that has been created or delivered due to the public tender or procurement procedures. But that's not the case, and from the standpoint of innovators, we understand that they are seeking for funding for the finance. And if they see that they may commercialize better and then earn more after using the funds, not the state or EU or any public funds, but the private funds, even if it costs them more at the initial stages, but still keeping the IPR rights, then naturally they will use the funds that guarantee them safeguarding their ownership of property rights. So this is the issue, as far as I understand, not only across the Baltics, the jurisdictions that we made the analysis on, but the issue EU-wide or maybe worldwide, I don't know yet regarding the latter, but the EU-wide is definitely. So we all see that we have to take that into consideration and structure our procurement documentation as well as the public contract provisions in such a way that would be creators friendly and innovators friendly, versus the mentality of bureaucracy and state. The same is the specifications. We heard about the golden plating. I'm not aware of that problem, mostly, at least in Baltics. This is not the main thing with over specification. I would say that it's more about what has to be in, or what has to be in the specification overall, because due to the lack of the dialogue, which I mentioned earlier, among the innovators and buyers, I think that the buyers still do not know what is the possibility, across the wall, or on the other side of the wall, what innovators might suggest, what they could buy by simply perfectly shaping the technical specifications and activating the innovation markets. So this is the problem mainly, at least as I see from the Northern Europe or Baltic states at the moment, not with the golden plating or something like that. Let's move on. We have here the small and medium enterprises participation in the procurement. We have the same as elsewhere. Small and medium enterprises or innovators, they are quite sensitive to the things which the bigger players are already numb, and they can handle them easily. So therefore, in order to have these SMEs entering the market of procurement or innovation procurement, we have to encourage the documentation, including the contract clauses, which would allow more often, even maybe in a smaller batches, but still more active funding and financing, accelerated payments, then easier access to the procurement without very sophisticated qualification or selection criteria and requirements. Again, synchronizing the thoughts with the previous slides and statements or insights that are related to what criteria, which would be more friendly, user-friendly for small and medium enterprises versus the bigger players, etc., etc. So this is not yet, as we have noticed within our team across the 3 Baltic states, accomplished. And this research showed that there is still way to go in order to simplify the legal ecosystem, so that the smaller and medium enterprises were attracted to these kind of procedures. Let's go on. And here we have the solutions. As you've seen, Estonian colleagues said that there is still limited competition in public procurement, and this is a challenge. I believe that professionals from different member states or elsewhere, they really have heard about the problem of limited competition or even one supplier tenders. So we see that it's the same in the Baltics, especially Estonia and Lithuania as well. Let's say public procurement office in Lithuania is still struggling and monitoring how to ease up the procurement procedures, including the innovation procurement procedures, in order to boost the competition, to have more economic operators and tenderers in the particular procurement procedures, because we have only 1, 2, 3, so across or different procurement objects, and this is a really bad sign. So as you see, my Estonian colleagues mentioned this as a main problem, and they think that the national practices should be changed in order to evade or escape this kind or prevent this kind of situations. Regarding Lithuania, I would say that yes, I'm still on that clear strategy, more consultations with the market and change of the environment. Let's say I have even myself presenting in practice my client in the court case where the EU funds are included into that, and the fund administrator rejected or then repealed the whole finance after everything has been already created, due to the fact that they afterwards started to think that the innovation was not the innovation itself, but was some sort of copycat of the first innovation, which already has been funded by the EU funds, and again by the same, or at least a few of the same innovators or economic operators. What I've noticed from that case, that again, the creators, the innovators, they understand innovation much wider than the bureaucracy and fund administrators see it. And somehow, where innovators think that they do something new and they go forward with some sort of new things which change the landscape, bureaucracy thinks that this is the misuse of funds and start to chase them by repealing the funds that has been already allocated to them. So this practical example where I have a pleasure and possibility to represent a client in a court as a professional show that there's a really mindset difference between two parties or two elements of the ecosystem we are talking about. And until there is this unified vision, we cannot expect for some breakthrough within the jurisdiction. This is regarding Lithuania as far as I see it. The same, more or less the same with the Latvian approach. As you see, my colleagues, first of all, what they do, they say that innovation procurement is often interpreted narrowly due to the lack and precise legal definition. So they believe that if it's defined in a broader, more clarified and precise way, that would be easier. But I would think that I would stick to my own insight, previous insight, that this is still the change of mentality, training, showing what this innovation is, having the members of that ecosystem in one place. I don't know if it's the conferences or shows or whatever you call it, you name it, but it's still they are still in the different corners of the same room, staring at each other as the strangers, So I think that this is the problem which happens not only in the Baltics, but as well as across the EU jurisdictions as well. That's it from north and eastern part of the Europe. And if you have any questions, I'm ready to answer them. Cool.
Thank you, David. That's really interesting what you were saying. And there was also a remark from the audience about the fact that probably the main issue is the use of the lowest price as an award criterion. So apparently that is also in line, of course, with your colleagues that they've said that you need to establish specific evaluation criteria related to innovation procurement and innovative solutions. So Can you say something about that? So the lowest price as an award criterion as such?
Yeah, so as you see,
Yeah.
So I think that at least from the Baltics, we might say that Lithuania is more fine-tuned to this trend. Let's say we have in the law saying that you cannot use the lowest criteria for the evaluation of the bids more than 50% of all your procurement procedures, and this goes to any contracting authority or contracting entity. Versus the Latvian, let's say, jurisdiction, which doesn't have that kind of regulation, and therefore they are suffering from that, as my colleagues have mentioned. So I think that again, in Lithuanian jurisdiction, we have perfect understanding that that paying less does not mean having better. And I perfectly remember 10 or 15 years ago, everyone who is a purchaser used to understand that if you pay less, then it's better. Now we see a really dramatic change in mentality, and this is a perfect example how things can change into the better way. And I think that we should analyze how this happened. I think that during the training, the case studies, and good cases and successful cases from abroad. And therefore now more or less every procurer in a more or less modern contracting authority or entity in Lithuania understands that paying less is really not the case. I mean, they are using the most economically advantageous tender or offer as an award criteria. So this is the same with innovation. I guess we have to understand that innovation itself is a more expensive object of the purchase. It will cost you more, but that's why you have innovation. So therefore, lowest price criteria will not be the case if you are about to engage into the innovative procurement or procurement of innovation. So
thank you, Davidas. Thank you for the answers, and please keep online because I expect that we have some questions at the end of our session. For now, I would like to go to Petter. Are you there?
Yes. Can you hear me?
The floor, yes, we can do. The floor is yours.
Thank you. So we have prepared a report on situation in Czechia and Slovakia, and here is an overview of gaps that we have identified that we believe are present in both countries. We are of the view that the allocation of IPR rights does not support a friendly allocation of these, and well, there's no encouragement for innovation. The reason is basically that the public buyers, they are afraid to buy on behalf of other contracting entities, or basically to leave space for the market. They believe they have to acquire maximum IPR rights, and the avoidance of vendor lock in all situations is sort of a mantra. As for innovation procurement or R&D procurement, this is a very niche area, and there is no definition in the public procurement acts of both countries, and nobody really knows what it actually is. There is a requirement to do public procurement with respect to a principle of innovation in Czech law, but again, this is something very broad, and hardly anyone knows what is meant by that. As for the pre-commercial procurement and public procurement of innovative solutions, these concepts are not broadly known, and they're not publicized and explained by the Czech administration. There are just the Commission guidelines, and no real explanation of these concepts for use by public buyers and also their suppliers in Czechia, and the same applies to Slovakia. Value engineering is neither regulated nor encouraged. There is no heightened transparency requirements there for innovation procurement. There is no specific guidance, as I said, for innovation procurement, and what we've also identified specifically in Czechia, there is a very strange implementation of the exclusion from the public procurement directives for research and development services. It's simply not written correctly and is very misleading. So that needs clarification, and we'll mention that also later. As for underutilized legal techniques, the difference is a bit different in Czechia and Slovakia. In Czechia, the innovation partnership is actually used, and we have identified 10 contracting authorities and dozens of situations where innovation partnership was used. No innovation partnerships identified in Slovakia. And as for competitive dialogue, this is actually quite widely used for sophisticated ID solutions in Czechia, not so much in Slovakia. What is interesting, the best value approach, this method is on the rise in Czechia. It's used in various situations. And yeah, that's quite interesting because there the price is of a secondary nature. And not so much in Slovakia. We have not been able to see that as widely used. Preliminary market consultations, however, are used in both countries quite extensively and have become kind of a standard on the market for more sophisticated public procurement. Talking about the challenges for public procurers, public buyers, as I was mentioning, they prefer safety and avoidance of risk. So connecting that with IPR, for instance, they are simply afraid to buy less for themselves or to share it with others, with the market, or with other contracting authorities, because they believe they cannot pay for the others, and they need to avoid any sort of vendor lock for almost any cost. And as I mentioned, there is very little information on innovation procurement, which would be practical and useful for public buyers and their suppliers. As for SMEs and challenges for their participation, the IPR provisions that are not favorable for them are of course a hindrance. The burden of participating in public procurement is very high. The public procurement procedures are very often challenged and require good preparation and specialized consultancy if a startup wants to succeed. This makes it quite competitive with the other larger companies that have their own departments where they have the competency to participate in public procurement procedures. And of course, there's also a limited awareness of the procedures, of the opportunities. They don't have the monitoring that the other larger companies have, and they have insufficient knowledge also how to behave in such scenarios. As for the administrative burden, I should also say that the procurement procedures are quite lengthy because the reviews are frequent and they can make the procedures very, very lengthy, even extending to years rather than months. There are certain measures that are positive for SMEs, specific legal provisions in both countries. For instance, in Czechia, there is a recent change which allows tenderers to get information about their standing in the tender. They can request that from the authorities so that they know whether they have a real chance to succeed or not. And in such scenario, they can simply either build capacity or relax and move their resources somewhere else. The economic capacity is not required in some cases, especially in CPV 71, which is basically these design and analysis services. So that's quite helpful, and there is no turnover requirements for startups. The new companies, they don't have to prove history, and also this method is not used as frequently, requiring a high turnover. Instead, bank guarantees may be required or insurance during the performance of the contract. So there we do not see a limit for the startups. In addition, there is a possibility in both countries to require direct payments to subcontractors, which may enable SMEs to participate as subcontractors more safely. And as for the bid guarantees, there is a maximum amount that can be required, and also various ways of fulfilling that duty. They don't have to pay the money; they can buy insurance for that or a bank guarantee. So it's something that is widely available on the market. We've also identified a certain interesting case law. I would say, for instance, that in Czechia there was a discussion about the preliminary market consultations versus market research, because market research was something that was used before. Then the directives introduced that change, and formalized preliminary market consultations became a norm. The Czech Review Authority has ruled quite recently that this distinction continues to exist, and that in case of an informal market research, it is not necessary to follow the publication requirements for the preliminary market consultation. So that's kind of interesting as for the preparation of tenders. In Slovakia, we have identified an interesting case where a vendor-locked contracting authority, which would normally be restricted from awarding a contract directly under technical exclusivity reasoning, was nevertheless allowed to do so in a scenario where basically the reason for that would exist despite of the vendor lock. So the review authority has allowed the contracting authority to continue as necessary and not prevented it from directly awarding the contract simply because of an unpermitted vendor lock. Last case, we have seen also a bidder requiring the Slovak Review Authority to forbid that a wide license be required by the public buyer. However, the Slovak Review Authority ruled that this is okay. It's up to the public buyer to require a broad license. And so this is maybe one of the limitations or points for discussion, where the public buyers sometimes require too much than necessary, and they are allowed to do so. As I said, the vendor lock mantra here is quite strict. So that's for discussion. And perhaps there should be more distinction about the exclusivity rights and the modification rights. Sometimes the public authorities require both, where they just should require modification rights instead of exclusivity, and they might actually allow the suppliers to profit from the results of the performance and their reusage for other market participants. As for proposed solutions at national level, I think the main thing is to establish guidelines internally in the member states, practical guidelines in the member states, and also suggestions for handling the IPRs, because that's very sensitive topic for the contracting authorities. They don't know how to approach that topic, and also it would be good to clarify the exemption for R&D in the Czech law and possibly also in the EU directive, because it is phrased in an impractical way that makes the implementation unnecessarily difficult. So that is everything for myself. Questions are possible.
Yes, thank you, Peter. Very interesting. We received some more remarks than a question. It seems there's a remark from the audience that that the use of the procedure of negotiations without prior notification was heavily overused in the past. And apparently one of the explanation of using this specific procedure was that the contracting authority didn't own the IPR. The first question is, can you say something about the use of this specific procedure of negotiations without prior notification? It's really heavily used in both countries.
That is correct. Basically, it is a result of maybe earlier decades when the contracting authorities were not very much aware of the risks of having once very, very strict licenses from the suppliers. So they became dependent on the buyers. And secondly, also they did not design the projects so that they would not be technically dependent on the buyers in addition to that. And because of this, they had to rely on any changes or subsequent contracts to be awarded by direct awards, by negotiated procedures without prior publication. It became an issue, and the review authorities were discouraging and penalizing the use of these, which then led to basically an overreaction to the vendor lock-in, and sometimes now the contracting authorities are requiring too much and pay too much for the licenses that are open, so that they are not then penalized for being in the vendor lock. So it is we are trying to find a balance in the society to that.
And the other question also relates to vendor lock-in. So what do you think what it means from your perspective? What is vendor lock-in from your perspective?
Yeah, well, vendor lock-in in let's say sophisticated IT projects is in many times it is a necessity. It is a technical necessity. De facto vendor lock-in is there in many situations, even though one may have sufficient rights theoretically. One may not be in a position to ask another supplier to do the work for the incumbent provider. But of course, the contracting authority should be avoiding that in as much as is practicable. And so it's about finding a balance and finding provisions and possibilities how not to become overly dependent. So
it's clear. Thank you, Peter. Okay, I suggest that we move to the final presentation of this round. Anna, are you there?
Thank you so much. And thank you to the experts for these great presentations. We move to the next slide. Let's see. We had some questions already, and now we go to the country analysis of the Netherlands, Austria, Luxembourg, Greece, Malta, Bulgaria, Cyprus, Croatia, Portugal, Romania, and Slovenia. I will try to be very thoughtful of the time. And first of all, I would like to really thank all of the experts who cooperate in these analyses, and if possible, and if they'd like to take the floor, and if it's possible, Stefan, it would be nice if they can give a word. But in the main aspect that we analyze in the framework of this study was to understand what's the current situation, as we explained. And we identified these 16 gaps in the legal framework related to the market consultations, the transparency of the notices, the way in which the technical offers are evaluated, the way in which the exemptions of the procedures to buy R&D or prototypes testing are in the different regimes. Also, the use of value for money award criteria versus lowest price, and has been already exemplified by the previous experts. And I'm not go all of these gaps, but what is important is that to mention that this was the methodology that helped us collect the input from the expert and compare the assessments. But indeed, in all of these gaps, we still see that in most of the member states, we have the possibility to improve already legislation that allows for the use of techniques that are not completely utilized, but there's still some gaps as well. So looking at the gaps, focusing on these 11 member states, we have found the following things. I will go quickly through these. Related to the friendly allocation of IPR, we do have, in principle, in all the countries, certain gaps because the legislation indicates that the contracting authorities or the public buyers, they can choose or indicate in the tender documents the distribution of IPR, but it's not encouraged that these IPR are remained or left vested in the contractors. The cases, of course, in which there could be these exceptions due to situations where, of course, the contracting authority needs to safeguard the public interest. But we also see that some measures or some special provisions in Malta, for example, or in Romania. We see also that in Austria specifically, they mentioned that in innovation partnership, the contracting authorities, the public buyers, are specifically requested to identify in the tender documents the IPRs. Regarding the definition of innovation procurement, you see that most of the countries, they do have a definition of R&D, but there's still the gap of the complete definition of innovation procurement that would be both the purchase of R&D and all deployment of innovative solutions. So there's something to do there. With regard to the best value for money or value for money award criteria versus lowest price, we do see some good practices. We see the use of these type of criteria in Austria. Actually, they use only the lowest price for standard products. In Croatia that the law indicates that 90% of the weight would be priced, but that 10% could be used for these criteria related to innovative aspects, for example, or quality aspects, etc. We see the same practice. Although it's possible to use these criteria, you see, for example, in Cyprus that most of the contracts, 90% of the contracts, the lowest price is being used. In the case of, we have looked into already Peter talk about the Czech Republic. If we look at Malta, you see that they do apply this type of criteria and they mostly request also the best quality ratio. I go to the Netherlands, there has to be a justification for the use of lower price. So this is an important requirement. Romania, there's a use also of this type of criteria. In the case of Slovenia, there is an encouragement of the law to use this sort of criteria in specific type of contracts, so it's already there. Regarding the language, a restriction for the tender documents also to allow cross-border joint procurement or joint cross-border procurement. We see that in Austria, there are no restrictions by the law to use other languages in the tender documents. Specifically, the country that has provisions in the law to really only use or even translate the documents to the language, and that would be in Portugal. Documents, everything needs to be translated to the Portuguese language. But you see also Slovenia allows for the publication in other languages of certain documents. Actually, in Malta, tenders are continuously published in English. Regarding the factor on value engineering, I mean, all of the countries would allow for this, the use of this technique is not encouraged, is not mentioned in the legislation, with the exception of Romania, that in specific terms and conditions you find the value engineering clause that could be used in order to present or request from the contractors value engineering change proposals that could improve the contract. But the interesting thing is that this technique in principle could be used, because also the provisions on the modification of the contract, the possibility to modify the contract during their term, is possible as well. With regard to the transparency requirements, like the innovation procurements actually in the contract notice has a tick on the innovation label, we see that there are still gaps. These are not published like this, except for Malta, that has specific measures in this regard. In principle, there is a lack of guidance on specific techniques on innovation procurement. We see that in the Netherlands, specifically Piano, and in Slovenia, there have been guidance already published, so these are good practices as well. Go to the next slide, and we see the mapping of the specific legislation that makes innovation procurement easy for startups. And here you can see that in Luxembourg and in Malta and Romania, there are specific provisions on advance payments. Also in Bulgaria, although it's not specifically for SMEs, but there are some measures in that regard. Regarding the maximum time deadline for procurers to finalize the evaluation of tenders, we see that there are some countries, for example, Malta, that requires that the offer is valid for 90 days. Well, that's some measure in that regard. In Portugal, it would depend on the tender documents. In the case of Romania, depending on the specific contract, it could be 60, 20, or 100 days. In the case of Slovenia, 90 days from the submitted offer. So regarding the financial compensation to startups and SMEs in case they participate in market consultations or negotiations or dialogues, you see that in most of the countries there is not such a provision, there's no such encouragement. In the Czech Republic, we see that there's some possibilities regarding the architectural competitions, but in Portugal, they're also limited to specific aspects. We can elaborate in case we have some time. On the clauses that protect also the subcontractors, we see Bulgaria has some conditions for no liability, and in Romania and Slovenia there are specific provisions protecting them. For example, also possibility of direct payment to the subcontractors. On the minimization of use of financial requirements, we also have some positive aspects in some of the countries regarding the limits on the guarantees, regarding on the possibility to have alternative evidence. That's the case also on Greece, for example, Luxembourg. Also limits on the certain financial requirements to the value related to the value of the contract, so that they need to be proportionally to the value of the contract, also the percentage of the guarantees that are required. So we move, being thoughtful of the time, mainly from these countries, the underutilized techniques are still value for money award criteria, so this could be more incentivated. Also the innovation-friendly IPR regimes, the use of multiple sourcing, that is something that really comes up. Also this transparency of the innovation label procurement in the notices, in the value, also value engineering change proposals, and also the use of market consultations. There have been some proposed solutions that coincide from the different experts and that relate to the proposed measures. First of all, they encourage a default regime that leaves the ownership to of the intellectual property rights with the technology vendors, unless there are exceptional cases that have justified reasons. It's also very important to provide more guidance on how to use this value for money award criteria, how to use market consultations, how to implement value engineering. We already mentioned the innovation label in the notices, and also another proposed solution is that guidance is provided on the exclusion grounds and remedies, so that it's clear what kind of self-cleaning measures can be used both by the contractor and the contracting authority. There's one specific proposed solution, or this is from the expert from Croatia, that she mentioned that it would be good to regulate the access to confidential data and innovation procurement within the confidential ring mechanism, so to also allow to preserve or protect the confidentiality, but in the case that there is court proceedings, there is guarantee the rights of those participating in a tender. And finally, it was mentioned, both to include the contractual obligations to protect the subcontractors and also, the members of a consortium, and many experts also coincide on the need of action plans at national level. We have some interesting case law. We'll pass it quickly. We have a case law in Austria about the use of the negotiated procedure without prior publication, and the court defined that a fully tested and developed product cannot be subject to a negotiated procedure because this is not falling under the exception of R&D, because it needs to be manufactured for the purpose. In Bulgaria, there is a case law on the publication of obligation to publish the market consultation reports. So the public buyer is obliged to publish the information so that you guarantee the level playing field. In Romania, regarding substantial modification, there are several case law that are interesting. A case law that indicates, for example, that even if the products offered were of better quality, if they were not in as part of the technical specifications, that meant that it was a substantial modification on that. Also, in another case, allowing the payment of an advance payment amounting to 6.5% of the contract value was considered as a substantial modification. And in another case, the extension of the term, even though the extension of the term that is not an exceptional circumstance is also deemed as a substantial modification. Go to Bulgaria, also a case on negotiated procedure without prior notice. In this case, it was important that there was evidence provided that there's no alternative or substitute that could be sufficiently good. So that was the main part of the case. In Croatia, we have also a case on the negotiated procedure without prior publication, in the sense that the contracting authority must prove that the procurement relates to an economic operator to whom the provision on the protection of exclusive rights apply, and that the conditions set in the law are met, so to prove that there's not a reasonable alternative or substitute. Regarding we have another case on IPR, on the allocation of IPR. This is a case on copyright, but I see that the time is a little going. So please, Stefan, I just give the floor to you and perhaps to any of the colleagues who would like to make a comment based on their analysis.
Thank you, Anna, for this overview. We receive a remark on the legenda and the color and the meaning thereof. Of course, we will provide it once you download the information. That's clear. What's interesting is that we have seen the overview for the EU member states. And of course, we would appreciate your feedback. We already received I just seen that we received some comments and remarks on certain countries. We will answer them later. But if you have now questions, you can ask them in the chat. For now, we're a little bit ahead of time, 2 minutes, so that's fantastic timing to say it like that. I suggest that we take a coffee break and we come back at 12:30 precise. So for now, thank you very much, and I hope to see you after the break. Thank you. So I hope you have enjoyed your coffee break. I suggest that we start with our second part. First, we will start with the non-EU regions and the general overview on the preliminary key findings. Asra, are you in?
Yes.
Excellent. You can present. The floor is yours.
Yes, thank you very much. Hello, everyone. My name is Azra Atalan, and I am a legal counsel supporting the Netherlands office of Corvers Procurement Services. And in this time slot, I will be presenting the innovation procurement aspects of the non-European countries. And this study, in the next slide, I can move the slides, yeah. Yes, perfect. This study has been conducted in 4 countries, the US, Japan, Canada, and South Korea. And for the US, we have collaborated with Professor Christopher Eukins. He is a professor of government contract law in the International Procurement Law program at George Washington University Law School. For Japan, we have worked together with Likle Grieg. He is a consultant and has been working within the scope of the EU-Japan Center for Industrial Cooperation for many years. For Canada, Yannick Riedel, an international trade lawyer, supported us. And for South Korea, Professor Dae-In Kim supported us. And we have concluded the study with US and Japan. The assessment regarding Canada and South Korea is still ongoing. And in this presentation, we will be tackling the assessments of US and Japan. In the next slide, here you see a table showcases the comparison of 2 countries, US and Japan, and the identified gaps in the legal frameworks. Innovation procurement faces challenges in both the US and Japan, but Japan has more legal restrictions that slow innovation adoption. Firstly, market research and preliminary consultations. The US system encourages market research before procurement, but Japan does not require it. In the Federal Acquisition Regulation, or FAR, it is regulated for federal agencies to conduct market research before procuring goods and services. And the tools for this could be industry days, requests for information, questionnaires, and press solicitation notices, etc. And for intellectual property rights and innovation, in the US, companies developing technology under government contracts can retain their IP rights within the scope of the Bayh-Dole Act. In Japan, IP rights from public contracts typically remain with the government, offering fewer incentives for private sector R&D. And regarding the definition of innovation procurement, neither country has a clear legal definition of innovation procurement or R&D procurement in the legislation. However, the US supports R&D through programs like SBR, while Japan relies on guidelines, not legal mandates. And for the best value for money aspect, the US has flexibility to use best value procurement, especially in defense and R&D. Japan has the overall greatest value system, which we will be tackling more detail in the upcoming slides, but it is rarely used outside the IT and public works sector. Most procurement decisions still prioritize lowest price in Japan. And regarding contract modifications, the US allows post-award contract modifications, enabling contractors to suggest cost-saving innovations by using the value engineering applications, and we will be tackling with that too. In Japan, contract terms are highly restricted after signing, limiting innovation during project execution. And regarding the transparency, both countries face transparency challenges, but Japan has more local level issues such as collision and limited e-procurement adoption. And the next slide, please. You see the main legal framework for innovation procurement in the US. First, we have the Federal Acquisition Regulation, or FAR, and this is the main set of rules for federal procurement. It provides flexibility for innovation, especially in areas like defense and research and development. And this means agencies can adopt new technologies without being stuck in rigid processes. And next is Other Transaction Authority, or OTA. This allows the government to make contracts outside the traditional FAR rules. It is useful for high-tech solutions because it speeds up procurement. For example, the US used this method to develop COVID-19 vaccines quickly. And then we have the Small Business Innovation Research SBR program. This program helps small and medium enterprises to get government funding for research and development. And many innovative startups benefit from this program to bring new ideas to the market. A key aspect of US innovation procurement is intellectual property rights. The Bayh-Dole Act and FAR Part 27 allow companies to keep IP rights for innovations developed under government contracts. This encourages firms to invest in research because they can later commercialize their own inventions. And the best value procurement model is another important factor. Unlike systems that focus only on the lowest price, the US uses competitive negotiations. This is similar to EU's competitive dialogue and allows agencies to consider quality and innovation alongside cost. And finally, there are sectoral variations in procurement rules. The Department of Defense follows its own set of rules called DFARS, Defense Federal Acquisition Regulation Supplement. This gives the military more flexibility in purchasing innovation compared to civilian procurement. It helps the DoD get cutting-edge technology faster. In summary, the US has built a system that encourages innovation procurement through flexible rules, support for SMEs, protection of IP, and a focus on quality over price. And these policies help the government to stay at the forefront of technology. And in the next slide, here we would like to, I would like to introduce you the value engineering applications in the US. And value engineering simply means increasing the value of the product by reducing the cost while maintaining the function. We will have examples in the upcoming slides. Here you see the legal background of this application. Value engineering is legally required under public law. This law mandates that agencies analyze costs and functions to improve efficiency. There are two key stages where VE is applied. Before the contract is awarded, agencies apply VE using OEMB circular. This ensures that they plan cost-effective solutions early in the process. And after the contract is awarded, VE continues through federal acquisition regulation, and this allows contractors to suggest better ways to save costs while maintaining quality. For example, let's say that government will conduct a highway project. The function of the highway is that it will allow vehicles to drive smoothly and safely, and the road must adjust as long. And before the award contract, the agency studies different road materials. They find that recycled asphalt is cheaper than and lasts just as long as regular asphalt. And this change saves, let's say, 20% on material costs. And this is where the VE applies before the award of the contract. And after the award, the contractor suggests using automated paving machines, let's say, instead of manual labor. This speeds up construction and cuts labor costs by 15%, let's say, and then there will be a value engineering change proposal here. So VE is a good practice that allows to apply before and after the award. It reduces costs at every stage while ensuring functionality. In the next slide, you see the Federal Procurement Policy Act. All government agencies must apply VE to major projects. It is not just about cutting costs. The analysis of VE also shall be directed at improving performance, reliability, quality, safety, lifecycle costs. And to do so, in practice, agencies spend 80% of VE efforts on program management and 20% on detailed value studies. For example, let's say that government needs a military equipment. Before purchasing a new military vehicle, the agency conducts a VE study. They compare the different materials and choose lightweight but strong alloys. This reduces fuel use and increases durability. And what is the result? The result is more cost-effective and high-performance vehicle. In the next slide, you see the OEMB circular. And this policy ensures that VE is applied to all government contracts. It includes senior officials responsible for cost-saving measures, policies and procedures to screen and scale VE solutions, training programs for government staff and contractors, annual planning and reporting to track cost savings, and awards and recognition for agencies that successfully apply VE. For example, let's say that there is a construction project, a government building project includes traditional air conditioning units. A VE study suggests using energy-efficient cooling systems instead of an AC. And this reduces electricity costs by, let's say, 30% over time. And this is why VE is essential. It makes government spending smarter and more efficient. And in the next slide, you will see a real life case, a real example of value engineering applied to labor processing. This case study comes from the US Army Corps of Engineers, Detroit district. It shows how VE improved labor processes and saved millions in costs. The problem was the RE team faced several inefficiencies in their labor management system, high costs, delays, budget complications, and a team was assembled to conduct a value engineering study. The goal was to analyze and improve labor process, reducing costs without affecting performance or quality. And the VE team identified key problem areas that were causing inefficiencies, fund processing issues. CRI finding was slow and complex labor distribution trackings, non-standard reporting made it difficult to monitor staff activities, high operating costs, expenses were too high due to outdated workflows, and budget complexity. The structure made it hard to allocate funds efficiently, and regulatory constraints, government policies slowed down decision-making, and early labor certification inefficiencies, delays in approving work hours, and unclear roles and responsibilities, lack of accountability among staff. The team analyzed each issue and developed improvements to optimize the labor workflow. And what were the results? The findings were presented to the district corporate board with the three major recommendations. First, better labor with and timekeeping workflows, ensuring accurate tracking of work hours. Second, enterprise-wide time and attendance systems, standardizing processes for consistency, and significant cost savings estimated at 18 million per year for taxpayers. And what were the key takeaways from this? The example proves that value engineering isn't just for construction projects, it also helps improve process efficiency, reduces costs, and streamlines government operations. And by identifying problems, optimizing workflows, and implementing better systems, agencies can achieve significant financial savings while maintaining high-quality performance. In the next slide, I will try to speed up a little bit. This is the legal framework for innovation procurement in Japan. Japan's procurement system is governed by public accounting law. This law is strict and rigid, ensuring public spending follows clear and formal procedures. And there is competitive open tenders. These are the norm, but unlike the US, Japan has few flexible procurement methods. The lowest price is often the main selection criterion. And Japan does have the overall greatest value system, and we will be tackling that with that soon. And there is no dedicated legal framework for innovation procurement. Instead, it is encouraged through guidelines, not legal mandates. And for intellectual property rights under public contracts, they are usually remain with the government, and this may discourage the private sector innovation. And strict rules on contract modifications mean that once a contract is awarded, it is difficult to change the terms. And transparency and competition issues exist, especially at the local level. In the next slide, you see the overall greatest value system in Japan. In this, we will delve into a little bit. This system allows the government to consider factors beyond just price when selecting a supplier. The public accounting law and local autonomy law allow OGV assessments, but their use require approval from the Ministry of Finance. And this makes OGV a less flexible option for public buyers. And in public works, IT, telecommunication, and R&D contracts is more common. However, in most sectors, lowest price remain remains the dominant factor. And total cost of ownership can be part of an OGV evaluation. This means buyers can consider long-term costs, but there is no legal requirement to do so. In the next slide, here, how does OGV work? Here you see a process flow used in Japan, specifically in the case of Ministry of Economy, Trade and Industry. And it outlines step-by-step process followed when using OGV for a government procedure. It starts with a tender notice, and the government agency announces the procurement opportunity, including project details and evaluation criteria. And then tender explanation meeting. A meeting is held in 10 days after the notice to explain the project requirements. And then we have the tendering, the bidding phase. Companies submit their proposal based on the criteria outlined in the tender. And then in 15 days, there is technical evaluation. Government officials assess bids based on technical criteria such as innovation, long-term cost efficiency, and performance. And opening of tenders in 5 days, financial bids are opened and evaluated. And here, a combined score of technical evaluation and price assessment determines the best value proposal. And contracting, the contract is awarded to the bidder with the highest total score, not just the lowest price. And then we have the results are published as soon as possible to ensure transparency. So, in brief, the OGV method enables Japanese procuring entities to make balanced decisions considering both cost and quality. By adopting this approach, agencies aim to achieve better project outcomes and value for public funds. And let's have an example to see how to apply this in real life. Imagine the government needs to buy new laptops for public offices. With the traditional lowest price method, they choose the cheapest option, let's say per laptop 500 euro. However, these laptops are slow, low quality, and need frequent repairs, leading to higher costs over time. With OGV, the government looks at both price and quality, and two companies bid, let's say one is 500, the other one is 700, but the expensive one that it offers a better speed, battery life, and durability. And although the second laptop is more expensive, it scores higher in performance and has lower long-term costs. The government chooses the better quality laptop because it will last longer and save money in the future. And this is how OGV ensures the best overall value, not just the lowest price. In the next slide, here we will have a look at the challenges in both countries. First, the US. While the US has strong policies supporting innovation, there are barriers that slow down the adoption and limit its impact. First, complex legal framework. The Federal Acquisition Regulation is over 6,000 pages, and it contains layered regulations from multiple agencies, making procurement complex and difficult to navigate. High administrative burdens slow down decision-making and discourage startups and SMEs from participating. And second, innovation procurement is heavily tied to defense. The most successful innovation procurement happens in defense and security sectors, especially in DoD and NASA. Civilian agencies lack the same flexibility to invest in high-risk, high-reward projects. And thirdly, slow contracting decision-making. Even with innovation-friendly programs like SBR and OTA, the procurement process remains slow and bureaucratic. And startups and SMEs often cannot afford to wait multiple years for contracts to be awarded. And in the next slide, here, these are the challenges in implementing innovation procurement in Japan. And there are 3 key challenges that we have identified in the assessments. First, slow adoption of innovation procurement methods. Japan's legal framework favors traditional procurement with a strong focus on lowest price. OGV exists, but it is rarely used outside IT and public work. And innovation procurement is supported only through guidelines, leading to inconsistent implementation. And second, risk-averse procurement officials. Government buyers prefer large, well-established companies over startups due to risk concerns. Officials rotate every 3 years and making it hard to build expertise in innovation procurement. And also, strict technical specifications make it difficult for new and innovative solutions to qualify. And thirdly, limited transparency and competition issues. Many local governments contracts lack transparency, making it harder for new market entrants. And collusion and bid rigging are still issues in public works, reducing fair competition. And what does this mean? Japan has some tools for innovation, procurement, but its strict legal framework, risk-averse culture, and transparency issues create barriers to broader adoption. And in the next slide, here I'm approaching at the end of my presentation, and I would like to present some key lessons learned from the innovation procurement in both countries, Japan and US. And first, legal flexibility encourages innovation. The US uses flexible tools like value engineering change proposals to support innovation. This allows agencies to adjust contracts and fund experimental projects. What about Japan? It has rigid procurement laws that discourage experimentation and adoption. And what is the lesson here? The legal flexibility is key to encouraging new technologies in procurement. And second, startups and SMEs need more support. The US SBR program provides a structured R&D funding, but not all companies can scale up to full contracts. Only the best projects get full support. In Japan, J Startups helps SMEs, but many struggle to qualify for government contracts. And why is that? Risk-averse selection favors large, established firms. And what can we learn from this? There must be a clear pathway from R&D funding to full procurement contracts, otherwise startups won't survive. And third, government buyers must be trained to evaluate innovation. In both the US and Japan, procurement officials prefer safe choices. Large, well-known companies, new and innovative firms struggle to compete. And why does this happen? Many officials lack training to assess new technologies properly. And what is the takeaway? Procurement staff must be trained to evaluate innovation based on merit, not just past experience or price. And number four, innovation procurement needs legal mandates, not just guidelines. In the US, agencies have structured innovation programs. In Japan, it relies mostly on guidelines, which leads to inconsistent adoption. And what is the issue? Without a legal mandate, innovation procurement may not scale. And what is the solution? Governments must create clear legal frameworks to ensure innovation procurement is constantly applied. And the last one, a best value approach should replace lowest cost procurement. The US uses best value procurement considering quality, long-term cost, and innovation, but there is room for improvement in civilian sectors. Japan has overall great value, but it is rarely used outside IT and public works. Most decisions still focus on the lowest price. And what should governments do? They should prioritize quality and innovation over short-term cost savings. Otherwise, public projects suffer in the long run. So this was the end of my presentation. Thank you very much for listening to me.
Thank you, Asa, to giving the insights in the US and Japan experience. There are some questions. The first question relates to the term of value engineering. The question is it well defined? Would it continuous improvement or something like that would be a more user-friendly approach or term? Perhaps for the audience, I think that, and perhaps Anna, you can step in, that the origin of value engineering relates to the Second World War with the engineers of General Electric came up with solutions. But perhaps you can explain that a little bit, Anna, to the audience.
Yes, of course, Stefan. Yes, indeed, value engineering, this is a term that has been coined many years ago, as you mentioned, during the Second World War and by General Electric, especially Lawrence Miles. It started as the value analysis because it was an analysis of the functions in order to understand what should the solution do. So what functionality it should cover. And so there was analysis of the value as equal to the function that you want to achieve. And later on, when General Electric applied actually for a tender for the Navy in the United States, then this trade secret of the methodology was used by the Navy and later on by the Department of Defense, and they started training engineers. So the name of the technique changed from value analysis to value engineering. So all these engineers at the Navy were using the technique in order to analyze the functions of the solutions they want to obtain. And by understanding the functions they want to achieve, they could identify the primary and the secondary functions and really target which changes or which substitutes they could handle. So alternative ways of doing things that could be better, actually, so that you add value in the sense that you add the functionality or add quality. Actually, by the practice, it seems that by doing this analysis, you decrease the cost, you save costs. So that's a little bit of the background and how value engineering came into place. And in the Federal Acquisition Regulation, there's specific definition of value engineering as this systematic approach to analyze the functions of every process, system, product, service, etc.
Yeah, but it's also important to understand that, okay, it comes from the private sector who was doing that, big companies like General Electric, to get better value when they bought things from other companies. The government took it over to also do that in government contracts. And it started with analyzing, when writing the tender specs, how can I get best value of money of what I buy? But it has also the other aspect of opening the possibility for companies during contract implementation to come with new innovations. So these value engineering clauses, which are then included in every procurement contract, to incentivize companies to come with innovations during contract implementation, after contracts have been signed, when new innovations pop up, and to also get financially rewarded for that. Because any cost savings that they can then generate for the public sector are split in two. The company gets half of the financial reward of coming with innovative proposals, and this is what incentivizes the whole system to do that on a regular basis.
And as a closing remark regarding the topic of value engineering, I would like to refer you to the recording of the Eafip webinar on value engineering of last year. There you find all the details that on value engineering, and also very good examples, not only from the States, but also from Europe. So that is on value engineering. There was another question relating to IPR in the defense contracts, if the IPR remains vested within the technology vendors. I think that we will comment that later. Of course, you always have to look at it from a case-to-case situation. In certain sectors, for example, in defense, the contracting authorities request the distribution of IPR rights in such a way that they can, for example, modify the technology or build upon the technology, etc. And is always related to high security aspects. So I think that's the same for every defense contract, but to be honest, we are not discussing this in detail now. But you're absolutely right. There is you need to look at the sector and the subject matter of the agreement in order to come to the right distribution of IPR rights as such. So that is on IPR rights. I think that we are on time. Anyhow, the other questions will be answered in the Q&A document. For now, Asa, thank you very much. It was appreciated. And I think that we can go to the final session of today, and that relates to the conclusions and our recommendations. So first, I would like to give you some ideas on the recommendations on the EU Innovation Act. I think it has already been mentioned that we need to speed up innovation procurement for the demand side. And how can we do that? Of course, setting a right target. The discussion from a legal perspective is that it's going to be a hardcore KPI, or is going to target that can move. But the idea is that we need to reach 20% of the total procurement spend, and we need to relate it to innovation procurement. So that's not only PCP, but also PPIs, etc. And in order to do that, if you have the target, you also need to translate that to action plans that can be monitored and that can be followed, etc. So it is encouraged that member states need to develop national action plans and anchoring innovation procurement in the R&I policies and programs, so to remove legal barriers for programs to support not only suppliers, but also to support buyers. And there should be an easy commitment to develop on the EU level an action plan with yearly tracking of progress based on common legal definition of course, of innovation procurement, and perhaps with naming and naming approaches or naming and blaming approaches, whatever is related to that. A very important discussion we had was on the joint procurement by transnational buyer groups. It has already been mentioned by our colleagues, the other experts, that there's always a discussion on the legal regime. Of course, in theory, we could provide and we could recommend to set up one legal regime for joint procurements, done jointly by public buyers from different EU countries to simplify buying innovative solutions together, enabling companies to grow across EU. For example, there was also a question about the EU institutions, if they follow the procurement rules. Yes, they do. They have aligned it with the EU financial regulations. So you could use this kind of schemes in order to speed up cross-border joint procurement by contracting authorities entities. Was there another recommendation, clear recommendations that has been discussed in all the presentations? We need to have a clear understanding of the distribution of IPR rights between the demand and supply side. So the Bayh-Dole type of IPR regime for all forms of public fundings, that needs to be aligned. So it is essential to enable the innovator to move from one form of public funding to the next and combine different forms of funding. And of course, the idea is that having an R&D is great, but to commercialize innovation is in the heart of the growth. So it's not only about doing R&D, but also think about the follow-up deployment to really get innovations out of the lab into the market. And as discussed, the IPR and the distribution of IPR as a rule should be done in a different way than it's been done now. As a rule, the IPR should remain vested with the contractor, of course, unless there's a reason for not doing that. But as a default, it should be done, and in all forms of public funding. So not only for procurements, also in grants, etc. There was an interesting question, I've just seen it, on the relation with state aid, so we will come back to that. But of course, at the moment that it has been set up from a European perspective, there is no issue on state aid. By doing that, then there's no issue. So this could be a clear recommendation. There are other ways to deal with that, but I do not want to dive into that now. There's a need to increase incentives for universities to transfer licensed academic IPRs. It's a very important issue that it seems that too much knowledge remains in the universities. The lack or operate a startup or they have an unfriendly startup IPR transfer licensing approach. Can be too slow or can be impractical. It can be too burdensome, whatever it is. Anyhow, it is hindering startups for commercializing academic-based innovations through procurements. So we need to set the right incentives to the universities to adopt a commercialization-minded and startup-friendly approach, and to share IPR and commercialization rewards with researchers to incentivize them. Basic principles should be implemented for all publicly funded procurements, so also those not subject to EU procurement directives. The lowest price awards should only be applicable for standard products. The value for money awards allows for strategic technology and strategic sectors. We have discussed that, and you have seen that from the presentations. We should give preference to functional specifications and use them to the maximum extent possible. A very important aspect is in the relation between the demand and supply side is to give to to implement the possibility to accept value engineering proposals in larger and smaller strategic procurement contracts. We have seen by evidence in the United States that is extremely successful, not only for the benefit of the demand side, but also for the supply side. We should allow and make available simplified multiple sourcing approaches. And I think that's very important also in the current time frame. We should establish clear conditions to reinforce EU strategic autonomy, ensuring reciprocity with the United States and Asia Pacific Rim. And when it comes to R&D services procurement, we should have the possibility to require a certain percentage of the R&D and also of the commercial production to happen in the EU. As you know, in the PCP schemes granted by supported by the European Commissions, we already have that as a mandatory aspect. So the procurement of innovative solutions, strategic technology sectors is vital. We should encourage use of multiple sourcing using the possibility to reserve one contract for EU suppliers only. Introduce possibility to give pricing advantage to EU suppliers for all non-WTO GPI covered procurements. And for both, we require reinvesting part of profits for keeping IPR ownership of further R&D production in the EU. So these are schemes that already have been used and utilized in different regions, and we see the success thereof. We need to facilitate the participation of the startups SMEs. Of course, we need to stop the unfair disqualification from procurement procedures. We should allow bidders to prove financial capacity via any means, not only the turnover. We also suggest and recommend to create a sort of black or grey list of unlawful financial contract conversions for business to government market. And we should not disqualify bidders solely based on a lack of performance history unless unusual professional experience or specialized facilities or something like that is needed for the contract execution. And we should allow bidders to correct simple administrative errors, omissions, and modified bids whenever legally allowed. An interesting recommendation is that we should create an EU-wide pre-qualification platform. Companies should only have to upload the supporting admin documents once for all procurements across the EU, and all admin docs that are already somewhere in the public database in member states should be automatically retrieved by or synchronized with the platform. So that would ease the administrative burden, not only for the supply side, but also for the demand side enormously, and could also lower the cost. The other recommendation, and as always, you have seen that over the last decades that we're always discussing this, to reduce the red tape and accelerate the procurement process, define clear timelines, publish whenever possible the preliminary ranking offers after the opening of the tender, set a maximum time limit for procurers to evaluate the offers. Sometimes the decision time is too long. We are aware of that from our practice, of course, and also require tender docs to be published in machine processable format. So automatic translation can be used. As you know, we already discussed that. The language issues can be and is one of the main hurdles for innovation procurement uptake, and this kind of new developments could really lower that hurdle. It's important to protect the basic rights of the small companies. So create an accelerate payment scheme regime for SMEs, probably within maximum 15 days, like in the United States, and not to create a scheme that creates the idea with with startups SME not to engage with the public side, because if they're not going to be paid, or the risk of non-payment or too late, then of course they will not engage in an innovation procurement process. Generalize the use of pre-financing for startups and SMEs in financial difficulties, but essential for the contract. And of course, require contractors. I think that's also a very important part, to respect minimum set of basic rights for subcontractors and consortium members. What do we mean with that? Is that what we sometimes see in practice is that the conditions set on the main contractor, a big company, are not being transferred to a smaller company or subcontractor, but the bigger company mandates more stringent conditions on the subcontractor. So we need to understand the value chain and how to make that more efficient and effective, and also to make it more reasonable. So these were the recommendations that we have on the EU Innovation Act. Then on the EU Public Procurement Directives, of course, there will be an overlap, but we will come to that later. First of all, we need to understand what we're talking about. So definition, taxonomy is clear. We need to have that. Need to have a uniform definition of innovation procurement across all the procurement directives. That should be mirrored also not only with the procurement directives, but also with the EU Innovation Act. We need to introduce the same definition of R&D procurement for example, for the Defense Procurement Directive, as well as in the classical and utilities directives. And we should include a definition of public procurement of innovative solutions in all civil and defense public procurement directives. There should be clear legal provisions to ensure effective implementation of innovation principle in the public procurement rules. Applying an innovation principle means to ensure that no public procurement ever blocks innovative solutions, and public procurement should actively encourage innovation whenever possible in the procedure. Otherwise, it will be impossible to reach a target of the 20%. We should mirror in all the procurement directives all above the provisions that make key steps in all procurement procedures innovative friendly and clarify procurement specification implementation aspects. For example, the IPR, and we come to that now. IPR, main issue. Is one of the top priorities in order, from my perspective, in order to create an innovation-friendly scheme. So the tender docs must define the distribution of the IPR rights and obligations in line, of course, with the IPR and the trade secret law. Important is that the confidentiality in the IPR trade secrets should also be respected not only during the procurement process, but also during the preliminary markets consultations. And we need to require equal treatment of bidders regardless of where in the EU they protect the IPR. As a default, ownership of the contractor's IPR should remain with the contractors. And of course, the public buyers, they should get free of charge adequate usage rights. And of course, that depends on the sector, that depends on the subject matter of the agreement, as I already discussed it. Public buyers can invoke licensing rights to enable third parties to exploit the results in exceptional situations. For example, like we have seen in emerging situations like COVID, perhaps also in other crisis situations, we need to have a sort of fallback scenario in order to exploit the results. Or what can also happen is that technologies and new inventions are not being utilized and not being commercialized for defensive reasons, while the R&D has been paid for by the contracting authority. As you know, in the PCP schemes, we already have set up, as we call it, clawback schemes. If a contractor is not able or not willing to commercialize its innovation, then the public authority has the possibility to regain or retain the IPR to him. Transfer of IPR ownership to public buyers should be justified. We call it the comply or explain methodology, are limited to predefined exceptional cases, e.g. when open licensing policy requires free publication of results relating to counterintelligence security issues, etc. Public buyers should ensure that contractors apply same IPR terms established with public buyers in contracts with their subcontractors, leaving subcontractors IPR barring unjustified exceptions, of course. And that was also relating to my former remark that we see that sometimes the main contractor are putting more stringent conditions to the subcontractors for the execution of a contract with a government, and that's not the idea. Certifications for R&D excellence. As you know, the member states and the European Union is heavily financing R&D, and we should have a sort of a certification mechanism in order to, one moment, we should have a certification mechanism to recognize high quality R&D outcomes. So such an EU seal of excellence and successful completion of relevant R&D grants should qualify as evidence for selection criteria on professional R&D capacity in innovation procurements. Example for if as a contracting authority is acting as a launching customer. Market analysis and open market consultation is vital for any procurement and of course also for innovation procurement processes. It should be mandated. We should require buyers to do such in the market research and state-of-the-art analysis. So because they need to understand if their preliminary needs can be tackled by the possibility of the market, if there's something is already available on the marketplace, or that's really a need for innovation or a combination thereof. And such a preliminary market consultation is needed before launching innovation procurement. Not that you're not only doing sort of desk research on your own, but also verify your findings with the market in order to fine-tune your needs and understand the market capabilities. So we have seen from practice, and you can go through the Eafip toolkit for that, and the Eafip webinars, that is absolutely needed to do such an approach. And also the Eafip methodology is aligned with this. We should enable companies to transparently find innovation procurement opportunities. And that is really important, that as you are aware of the fact that at this moment there's omission in the tender forms, we don't have a tender form for an open market consultation. We know that's going to be published. So, and once it's that, it should be mandated to use it as such. And require buyers to use a new field in the existing TED notices to indicate if it concerns an innovation procurement. Then for the more legal experts on this, we were also looking, when we had the discussion with our legal experts from a European perspective, also with the national experts, to see how we can align or to see if there were possibilities to align further the existing GPA with the procurement directives. And perhaps there's a room for alignment on the Article 13F of the WTO GPA on the specific procedure for limited production supply of products, because that article not only relates to products but also to services, and we feel that it could be interpreted to enlarge it to a limited production, limited supply at TRL9. However, this is one of the things that we would like to recommend and to discuss further. It has already been mentioned in some countries, the implementation of the procurement directives and also Article 14 as such of the procurement directive, it causes confusion. So please rephrase the R&D services exception in such a way that it can be easily read. Now we always have to explain it, what it means. And so clarification is needed on that. Not to forget, also in this time of strategic autonomy and geopolitical area we're in now, we should clarify the security-related exemptions in a more better way. We should explain what essential security interests mean, what means disclosure contrary to security interest means, etc. So harmonizing practices across the EU would enhance and will enhance the efficiency of the directive. So these are my conclusions and recommendations, not only mine, they are part of the whole team. And we feel that by adopting these recommendations, we will strengthen the EU capacity to leverage innovation procurement, to modernize public services, and of course, to boost industrial growth, including startups, SMEs, and of course, any and all innovative companies, because also big companies can favor from that approach. Enhanced EU legislation will enable public buyers to drive technological advancements and secure Europe's competitiveness and strategic autonomy in the global markets. And of course, that is really needed nowadays. For now, these are my recommendations. That is my part. I'm going to see if I find any questions already in the chat. Let me see. Okay, this IP target should be in the European semester. I don't know exactly what that means, but I think that the target of the 20% as such is, I think we have seen over the last, 10, 15 years, and Lieve, perhaps you can help me, that you have done a lot of research on this from a European perspective. Innovation procurement should be in the heart of economic growth. And until now, we are discussing it from a voluntary approach and capability aspect. But I think now it's time to have more mandatory approaches, but also to simplify the approaches. Lieve, I'll leave it to you.
Well, yeah, the economic semester is the big package of measures for increasing economic growth and economic reforms in member states that are revised every year. So they don't only touch about procurement, they talk mainly about economics, but yeah, it's important to see innovation procurement as a driver of economic growth indeed. Where exactly to put such a target, I mean, I don't know. I'm just listening to the recommendations of the experts, whether it should be in the economic semester or in the Innovation Act. I mean, that's another discussion. Just so you know what the economic semester is, and that there is indeed a link between economic growth and innovation procurement.
Excellent, thank you, Lieve. I'm not seeing any other question. Perhaps there are some other questions that I can answer if there are any. Let me see. Okay, let me see. Okay. There's a question, and perhaps you can also that all the country reviews are very interesting, but I wonder where is the target audience. I, as working for an RPO, have the feeling that is the matter for legislators, national and EU, and public authorities. I wonder where the place for an RPO may be. I cannot answer the question, so perhaps, Lieve, perhaps you can answer that question.
Yeah, so if I understand well, you mentioned RTO, Research Technology Organizations. Yeah, they are often the place, universities and research technology organizations where innovations are born, at least academic research, where it can create the innovative ideas. And the important thing is to make sure that these innovative ideas can be commercialized. So can RTOs play a role in that? Yes, in two ways, I think, in fact. First of all, by ensuring that when innovative ideas are created within their organizations, that they have then also an IPR transfer and licensing policy that allows spin-offs, startups, innovative companies to use these innovations to commercialize them, that they don't keep stuck within the university because the transfer licensing system is too difficult, too complex, not startup friendly, and so on. This was one of the things that you already mentioned, right? But they can also do a second thing because, yeah, academic institutions are often also public organizations, so they are public buyers themselves also. They do highly innovative work, research, and so on. So they often buy also high-tech technological equipment. Think about, high-tech microscopes, supercomputers, whatever, high-tech equipment, quantum computers, stuff like that. So in the way they procure themselves, they could also lead by example and show that, we are high-tech institutions, we know a lot about innovation because we do lots of research ourselves, but we also buy in an innovation-friendly way when we need to buy some equipment from the market.
Sorry. I see that there are some questions relates to what is the EU itself, the European Commission doing itself on innovation procurement. There are some questions on that. And do you have examples of value engineering approach within the financial regulations?
Very good question. A very valid question also. Well, what is the European Commission doing on innovation procurement? Like the experts said, they want us to create an action plan, which means that everything is not yet in place, but we are gradually trying to also improve our own way of procuring. You may have seen that the Commission and other institutions have already launched more innovation procurements over the past years. That's not just procurements to buy high-tech equipment, but also procurements to get it researched and developed. We even are doing pre-commercial procurements, for example. And in those, we have already applied, for example, the IPR regime that leaves ownership of IPR with contractors, with all the things that you've heard that the experts recommend here. We have also included multiple sourcing under the financial regulation as a possibility. What else? Value engineering is something, I don't know if anybody has already used it. I have not gone through all the procurements that institutions have ever published to see if anyone has already used it, but we don't have provisions in the financial regulation yet, I should say, because, you know, we should maybe develop that in the future, of course, that really explain it and so that everybody is aware how to implement it if they want to do it. That could be for sure an improvement to look at. That's right. Good suggestion.
On the other side, you also see good examples. You mentioned, for example, the PCP schemes that have been initiated and implemented already by the EU. I believe that also Hadea has just launched a huge PCP on vaccines, if I'm correct, Lieve. Multi-million, I think few hundred million, I don't know exactly the amount, now a huge PCP project.
Yeah, it's the Director General in the Commission responsible for health emergencies and how we respond to that. So after the COVID crisis, we never want to end up in the same situation again, where we were not enough prepared. So now we launch in advance R&D procurements, like the one that is being launched now, to develop solutions that could tackle future, crisis situations like COVID, that could develop new vaccines for future evolutions of influenza type variants and variations that may exist, and how we can get those solutions already developed, tested, and brought to the certification authority so that if ever they are needed, whenever a crisis emerges, we will have them and then quickly deploy them.
Exactly. So we are almost at the end of our webinar. Let me see. There will be, as stated, we will answer to all the questions, and you can download the material later as well. You can also look at the recording of the session and download the presentations. Before I go, let me see. So interesting questions, but we answer them later, also for time reasons. For now, I would like to go to the closure of this webinar. First of all, I would like to thank all the presenters, of course, the European Commission. Lieve, thank you very much for presenting your insights and the overview and your answer to this. Of course, to Mr. Inotais, really appreciated that he gave the introduction from the EU perspective. Not to forget all our experts. We still have a lot of work to do, as always, but in the short time frame already, as always, if you work together and you have the passion, you see the passion between all the experts, it's really enjoyable to have this atmosphere and to come to these results. As a last way, you have seen all the recommendations and that we have come up with. Of course, you can have also your own ideas to recommend and to send the recommendations in. As it has been mentioned, I think the open consultation with DG Grow is still open till the beginning of March, so you can give there your recommendations or ideas. And I think that's also one of the strengths that we have in the EU, that we have an interactive approach between all the stakeholders in order to improve our rules and legislation and to make, when it comes to procurement, and innovation procurement the most attractable place to be and to work in Europe. And by that, I would like to conclude, and I would like also to thank the back office, Maria, Matti, Marlene, as always, great to receive your support. And for now, I would like to thank you for your attention and see you later. Thank you very much. Bye-bye.